What a delightful Friday morning, everyone. Before we start, may I ask our Zoom participants to please give us a quick like or thumbs up if you can hear us crystal clear. Awesome. Thank you very much for all of your responses. To start our today's program, I request everyone to put ourselves in the most mighty and holy presence of our Lord Jesus Christ. Loving Heavenly Father, we come to you this hour asking for your blessing and help us as we are gathered together. We pray for your guidance in the matters at hand and ask that you would clearly show us how to conduct our work with a spirit of joy and enthusiasm. Give us the desire to find ways to excel in our work. Help us to work together and encourage each other to excellence. We ask that we would challenge each other to reach higher and farther to be the best we can be. We ask this in the name of the Lord Jesus Christ. Amen. Once again, a wonderful morning to everyone and sabay-sabay po tayong lahat. Thank God it's Friday. This is your facilitator, Monica Marie Sadia from the Capacity Development Division. And welcome to the fifth and final day of the online training for the Municipal Local Government Units and Government Procurement Reform Act, or the Republic Act number 9184 in its 2016 revised implementing rules and regulations, batch 9, brought to you, of course, by none other than the Government Procurement Policy Board Technical Support Office. Kumusta po ang ating mga gising? Ayan, from LGU La Paz, Sir Raylenor, maayong buntag sa tanan, and Ma'am Brenda, maayong buntag. To my mother's dialect, marhay na aga po sa Indong Gabos. Ayan, nakapag-coffee na po ba tayo? Sa mga hindi po nagko-coffee like myself, no hot chocolate or any preferred morning drink? You can also, before we actually dive in our final learning sessions, let us add more things to love about today by having first our quick and last morning exercise. And so today, for our last morning activity, we will be having one of the crowd's favorite. This is personally my topmost favorite energizer po, and it is called Guess the Movie Title. This is also very simple po. We will be flashing a scene or a clip from classic Filipino movies, and all you have to do is drop the correct movie title in our Zoom chat box. For our Facebook Live viewers, magandang umaga po sa inyong lahat, and thank you all very much for staying with us until today. All right? Ready? Ready na po tayo for our first classic Filipino movie. Let us all watch this.
Sana, tuwing umiinom ka ng alak, habang inihitip mo ang sigarilyo mo,
Sir.
habang nilulustay mo yung mga perang pinadala ko, sana maisip mo rin kung ilang pagkain ang tiniis kong hindi kainin para lang makapagpadala ako ng malaking pera dito.
Ayan, ang bilis po ni Sir. For our Facebook Live viewers, you may also join us po through the Facebook Live comment section. And the answer is anak. Congratulations to LGU Lemery Batangas and LGU Mendez, Bibilis. All right, for our next classic Filipino movie.
Kahit isang gabi lang. Pahiram ng asawa mo.
Mm-hmm. That's the answer. We have one more try, legal wife. Ayan, the correct answer is one more try from LGU Mendez, Miss Camille Fidel. Congratulations po. From LGU Agoncillo, they got the correct answer as well. Ayan, for our third movie title. Shout out po to Sir Randy Asatas from LGU San Isidro, Northern Samar.
Trying hard. Copycat.
Bilis ng LGU Lemery. Between walang ningning, let's all see. That's the correct title. And that's correct. Congratulations po, Ma'am Victorina Cabrera from LGU Agancillo, Batangas. We're down to our fourth movie.
She loved me at my worst. You had me at my best. But we never had fun.
Ayan. Ma'am Joynaline from LGU Lemery, Batangas. Ma'am Victorina from LGU Agancillo, One More Chance. From Municipality of Tungawan, Ma'am Merlinda, One More Chance. Ang sagot po nila, is that the correct movie title? Yes, and that's the correct title. I think we are down to our final movie clip. Ayan.
Oh yes, kaibigan mo ako.
Kay Julina and Marvin ay halatang mga 90s baby, and isa na po ako doon. Alright? We hope you enjoyed po our last morning exercise, because we sure did. Now at this point, before we dive into our lecture proper, of course, let us first have our final set of early bird awardees. Ayan, congratulations po to our early bird participant, to our first early bird participant from ayan, LGU Irosin Sorsogon, Mr. Oliver Gabriel Encinas Franche. And to our second early bird participant, congratulations po to Miss Princess C. Gile from LGU Irosin Sorsogon po as well. Congratulations po again, and our event secretariat po na shall coordinate with you on how you may claim your special token. Also, a very important reminder po, please accomplish the participants' daily attendance day 5 by clicking the link provided by our event secretariat, as this will be part of the requirements for the provision of your respective certificates. So at this juncture po, allow me to just have a quick recap of yesterday's learning session. Ayan. So yesterday po, we had an entire session on alternative methods of procurement, where we had an extensive discussion on the various alternative methods which may be utilized in government undertakings and its appropriate use based on the prescribed conditions, procedures, and documentary requirements. Of course, led by our resource speaker, Mr. Antonio Faunilian Jr. Today, we shall be having 2 full sessions on protest mechanisms and remedies and on blacklisting guidelines, respectively. So without further ado po, it is my honor to introduce to you this learning session's resource speaker. Today's resource speaker is a Career Service Executive Service Officer 3 and a certified public accountant by profession. He has an extensive background as a resource person and public financial management, both for a national government agency and for local government units. He was a Civil Service Commission Scholarship Program grantee and honored with the highest distinction for his Master in Business Administration at Ateneo de Davao University last 2004. He also attended international studies, Frenetic Leadership Class Batch 3 by the Development Academy of the Philippines and Japan International Cooperation Agency. Also, Virtual Foreign Study Mission or Observational Visit in Japan by Development Academy of the Philippines, Public Management Development Program, and National Graduate Institute for Policy Studies. He is a GPPB recognized trainer on Government Procurement Reform Act and its revised implementing rules and regulations. He was recognized as an outstanding employee in 2012 in line with the government-wide implementation of performance-based incentive system in DBM Region 13. He was also awarded as the most influential recognized speaker for Mindanao by the Government Procurement Policy Board Technical Support Office in 2019. Joining us today, the Regional Director of the Department of Budget and Management, Regional Office 7, ladies and gentlemen, Director Vicky L. Sanchez.
Yes, thank you, Ma'am Monique, for the very generous introduction. So, maayong buntag sa atong tanan. Good morning, buenos dias. So, I believe the nationwide ang coverage natin at this time. At live pa tayo sa Facebook, if I'm not mistaken. Okay, so we'll proceed now. We'll dive into the lecture. So, allow me first to share my screen. First, the first module muna, no? Share screen. So I hope na visible na po yung ating screen and we'll be able to start na. Okay, so can I have a thumbs up muna? Ayun, meron na. Okay, so we'll proceed with the first module. No? Parang ano lang ito, online class kasi naka-modules yung ating mga sessions. So module 6 na ito if I'm not mistaken, and you've been through a lot, no, sa ating whole week. So medyo relax na tayo ngayon kasi some of most, if not most, no, of my items here would be just a reiteration lang. Of course, we will look into the legal, no, aspects of the more legal aspects of the procurement law. Kasi nga, I understand that natapos na kayo for the first 4 sessions or 4 days of sessions. So you would notice later na medyo may mga reiteration na lang na gagawin natin mamaya just to emphasize, no, some points. Okay, so normally itong topic na na-assign sa akin would be normally assigned, no, to a attorney or a lawyer, no, recognized trainer. In fact, in the past batches, na-assign ito kay Attorney Atis and Attorney No, procurement activities are concerned. Okay, so I believe we're all ready. So we'll proceed now with the objectives. So basically, the objectives of this particular module is that by the end, no, of this module, ang participants natin would know the grounds and remedies of offenses committed in relation to the conduct and or a participation to procurement activities. So isa-isahin natin yan mamaya, no? Ano po yung mga offenses na posibleng makomit, no, ng ating mga procurement prospective bidders or even mga contract implementers, no, or mga contractors, supplier, distributors, consultants. And of course, ano po yung mga remedies nila if ever na tingin naman nila ay sila po ay nadihado. Of course, sa ating namang part din, no, sa procuring entity, ano po yung mga pwede nating gawin. So, malalaman po natin yan mamaya. And understand the procedures and considerations of how, no, to resolve a request for reconsideration and or protest. So, papasukan din natin yung protest mechanism. Okay, so ito po yung outline ng aking presentation. First, we will be discussing, no, the penal, civil, and administrative provisions. Ito po yung sinasabi nating 3-in-1. No? Merong administrative, civil, and criminal na mga liabilities na ating pag-uusapan at paano po natin ito maiiwasan. And of course, liabilities, no, under RA 3019 or the Anti-Graft and Corrupt Practices Act. No? Bakit po nating pag-uusapan ito? Kasi nga may malaking relasyon po ito at impact, no, sa ating ginagawa sa procurement. Kaya dapat kasi nga may mga bago, no, na mga procedures, may mga bagong forms or may mga bagong requirements na dapat nating pagtuunan ng pansin. Kaya hiniwalay natin. So mamaya, no, may module 7 tayo for this blacklisting guidelines. Okay, so let's proceed. So highest standards of ethics ang required, no, sa lahat ng mga ating mga procuring entities na nag-handle, no, ng mga procurement activities. Not only, no, sa kanila, kahit na mga yung mga end users, no, and even simple public servant, no, kasi nga nakalagay naman yan sa RA 6713 natin, yung Code of Ethical Standards, no, for government employees in the public service, no. So meron tayong ino-observe niyan na in fact 8 norms of conduct yan, no, nakalagay na kailangan natin i-observe yung commitment to public interest, professionalism, justice and sincerity, political neutrality, no, especially na election season ngayon, responsiveness to the public, and then nationalism and patriotism, commitment to democracy, and of course, simple living. So yan po ang expected sa atin being a public servant. Of course, yung mga counterparts naman natin sa private sector, yung mga sumasali no sa ating mga procurement opportunities, yung mga bidders, contractors, suppliers, manufacturers, consultant, no? Sila din expected din na tumupad no or sumunod sa mga alituntunin ng ating batas. Of course, ethics, no? Highest standards of ethics kasama din sila sa dapat tumupad ito. Of course, meron tayong sanction, corresponding sanctions if ever bidders determined to have committed corrupt, fraudulent, collusive, coercive practices by the government will not be eligible to bid in its project. So ito po yung sanctions yung sabi natin kung makakommit sila nitong mga practices, no? Prohibited practices, which we'll be discussing in detail later. So yan po, pabungat pa po yan. So ito na po yun, no? Yung mga prohibited practices. We classified this into 4, no? General classification, although alam naman natin na meron niya mga details na kailangan nating pagtuunan ng pansin. So first, ito po yung collusive practices. When we say collusive practices, ang ibig sabihin lang nito ay scheme or arrangement between 2 or more bidders to establish bid prices at artificial level or non-competitive levels. Alam naman natin, no, na-discuss sa inyo siguro on the first day, yung isa sa mga governing principle natin sa RA 9184 is the competitiveness principle, wherein we want, no, as much as possible to give equal opportunity to all eligible bidders to participate, and of course to provide them the level playing field, no? Patas lahat, na wala pong pabor-pabor, no? So to speak. Kaya nga kung mayroong mga ganitong mga scheme or mga arrangement, yung usap-usap, no, yung mga bidders na magsasali na may mga arrangement na ipapaboran yung isang bidder or meron silang mga kausapan o usapan na ibibigay sa kanya kung ang isang kontrata basta may corresponding ganon. So hindi po pwede yan, no? Collusive practice po yan. So bawal na bawal po yan. And kung ginawa po yan nila and then meron tayong mga ebidensya as a procuring entity, then no, we can always file cases and disqualify them and even blacklist them. And of course, corresponding criminal charges will also be faced by these mga violators, no? Of course, ito pong corrupt practices, very common ito, no? Basta gobyerno, alam na alam ng mga public yan na prone yan sa corruption, lalong-lalo na yung mga may survey yan na ginagawa, no? Yung ating mga NGOs or civil society organizations kung sino po yung pinaka-corrupt, no? Perception lang naman, hindi naman talaga natin malalaman totally kung totoo ba o hindi. Basta public perception na itong agency nito ay corrupt dahil sa maraming projects o maraming mga kalokohan na na-discover or na anomalya, no, mga ganon. So as much as possible we should, no, alam naman natin na mahirap natin walang bahala, no, itong mga ganitong mga perception, kaya nga dapat nating i-pursue na hindi tayo malagay, no, sa ganyang mga sitwasyon, no? So improper and unlawful enrichment of oneself or others, no, ito po yung corrupt practices. And of course by misusing, no, the position in which they are placed, and it includes the offering, no, giving, receiving or soliciting anything of value to influence the action of any such official in the procurement process or in contracting, execution, entering or on behalf of the government into any contract transaction manifestly, no, and grossly disadvantageous to the government, whether or not the public officer profited or will profit thereby. So yan po yung mga corrupt practice po na pinagbabawal. Of course, alam naman natin yan kahit hindi natin i-discuss, no. Once na meron tayong hinihingi, merong binibigay, no, yan po ay basta hindi kasama, no, hindi naman required o hindi kasama sa mga processes, no? So yan po ay corrupt, considered na corrupt practice yan. Of course, coercive practices, harming or threatening to harm directly or indirectly, no, or persons or their property, no, to influence their participation in procurement process or affect the execution of the contract. So yan po, yung pananakot, yung pag-threaten, no? Or even, no, kahit hindi so more than threatening pa, kahit pananakit, no, sa kapwa, no, directly or indirectly yan. Kaya very careful dapat tayo, no, kung tayo ay lalong-lalo na kung tayo ay public official, no, and then may under sa atin na mga subordinates, no, na tinatakot natin na kung hindi niyo tutuparin o hindi niyo susundin ang aking mga instructions to circumvent, no, yung mga dapat na gawin para sa procurement process, no, para may mapaboran o mapagbigyan ng kumpare, kaibigan, no, or even relative, no, sa ating mga procurement transactions, no? So yan po ay kasama dito yung pananakot. Say for example, hindi mo i-promote o hindi mo i-consider sa promotion yung isang subordinate mo na involved sa procurement process, no, kasi nga hindi niya kung hindi niya gagawin yung utos mo, no, to give favor, to provide favor sa isang kakilala mo na nagsumali, no? So yan po ay coercive practice po yan at bawal na bawal po yan. Even yung mga contractor, supplier, no, or bidders, yung pananakot sa mga bids and awards committee, secretariat, or to the even to the hope, no, na pag hindi niya ibibigay yung kontrata, no, say for example, ilang bilyong pesos na kontrata yan, ay hindi po siya may kakausapin na mas mataas, no, backer siguro or something. So yan po ay pananakot, kasama po yan coercive practices. Of course, yung fraudulent practices medyo malawak yan, pero alam naman natin na marami yan, no, maraming mga sitwasyon na pwedeng mag-fall dito sa fraudulent practices. Pero basically, ang definition niyan or ang sakop niyan ay ang misrepresentation, no, of facts in order to influence a procurement process or the execution of a contract to determine to the detriment, no, of the procuring entity, and includes collusive practices, no, among bidders prior to or after bid submission, designed to establish bid prices at artificial or non-competitive levels and to deprive the procuring entity of the benefits of free and open competition. So alam naman natin bakit kailangan natin wala talagang halong mga ganyan, because we want as much as possible, no, to provide the best quality, no, at the best price, no, for the government. Kaya nga tayo ay pumapasok sa bidding process, sa mga alternative methods of procurement, kasi nga we want the best, no, for the government at the right price, kasi nga we want to attain, no, value for money. Alam naman natin na very scarce ang resources ng gobyerno, particularly financial resources. So we want to maximize, no, yung ating pondo na na-trust sa atin sa
our question po, no, gentle reminder lang po again to our Zoom participants to please be mindful of our microphone settings. All right. So for our first question, all are covered by penal provisions under RA 9184 except one. Letter A, misrepresentation. Letter B, collusion. Letter C, connivance. Or letter D, malicious mischief. For our Facebook Live drop your answers through our Facebook Live comments section. Again, the question is, all are covered by penal provisions under RA 9184 except one. Is it misrepresentation, collusion, connivance, or malicious mischief? The answer, 37% of our 40% of our Zoom participants are currently answering our first question. For the rest po, please let us know if you're having trouble or challenges answering through our Zoom pop-up poll, so we can assist you po accordingly. All right, let us have our results, please. Answer, 75% po answered malicious mischief, 15% answered misrepresentation, and 10% answered connivance.
Okay, so medyo maganda yung resulta natin ng first knowledge check for this morning, and I'm happy to note that tama po, no, karamihan malicious mischief po ang answer sa ating first knowledge check question. And kasi nga na-present po natin kanina no na yung major classification ng mga prohibited acts wherein isa po doon yung collusive practices, yung coercion, yung misrepresentation naman ay kasama po yan sa fraudulent practices na discuss natin earlier. Yung malicious mischief kasi nakalagay po sa Google, ito po ay the act or offense of intentionally damaging or destroying another's property. No? So one good example of this, yung vandalism, yung paninira ng mga bagay no, na hindi sa'yo. No? So hindi po yan kasama sa ating prohibited acts. Although po, medyo papasok po siya sa coercion, no? Kung ang intention mo ay pananakot. No? Pero kung hindi naman, so hindi po siya kung fall yung malicious mischief sa ating mga prohibited practices or acts. Kaya yan po yung answer. So I hope naintindihan po ng ating mga participants yung ating knowledge check question. So we'll proceed.
Yes, sir. But before we proceed po to the next part, shout out lang po ako to our Facebook Live viewer, Ma'am Maureen from LGU Pateros, Metro Manila. All right po, for if you would like to join our 10th and final batch next week, exclusive of course to municipal local government units, you may still join us because registration is still open. All you have to do is to just register through the link that is pinned by Billy Bayong in our Facebook Live comments section. All right, Director Ricky, I think we have 9 slides po for the next part of our lecture discussion. So back to you po, sir.
Thank you, ma'am. So shout out po dyan sa mga Facebook Live viewers natin. Okay, so let's proceed. We'll now dive into the penal provisions na. So we already discussed the premise na yung mga preliminaries, no, na mga kailangan natin maintindihan or malaman ng mga prohibited acts. So we'll go to the provisions of RA 9184 relative to this particular topic. So nakalagay po dyan, ano po yung coverage natin. So nakalagay po yung dalawa, general po yan na classification sa mga coverage natin. Ito po yung mga public officers who commit any of the acts enumerated under Section 65.1 of the implementing rules and regulations, and then of course yung mga private individuals who commit any of the acts na ating i-discuss as enumerated under sections 65.2 and 65.3. So isa-isahin po natin yan. So both ang covered nitong mga penal, civil, and administrative provisions, both private and public individuals. Then, ang coverage po ng penal clause ay nakalagay din specifically sa both manual or electronic na mga processes or procurement processes. The penalties and offenses under RA 9184 and its revised implementing rules and regulations shall cover all types of procurement, whether done manually or electronically. Nakalagay po yan sa section 65.4 of the implementing rules and regulations. So way back pa, cover na foresee na po ng ating procurement law na dadating talaga tayo sa panahon na magiging electronic na itong ating procurement processes. Kasi nga, although na-envision na ito matagal na, pero medyo may mga glitches na nangyari sa ating e-bidding na tinatawag. Kasi medyo matagal na rin to na pilot test, and then mayroong mga hindi na-realize na mga requirements sa ating field jobs. So tuloy-tuloy naman ang ating pag-develop niyan, at itong modernized field jobs na tinatawag natin ay hopefully ma-launch na next year at the start of the year, kasi nga parang final stages na lang sila ng ating mga implementation nito para maging ready to adopt the electronic bidding. But of course, meron naman mga interim na guidelines na nilabas itong ating GPPB to provide us other opportunities or ways to conduct electronic processes or yung some form of electronic processes sa ating mga procurement process. Hindi naman sa buong process, pero meron na such as the electronic submission of bids and opening. Yun po. Pero the whole process hindi pa po siya applicable. Pero at least paunti-unti darating din tayo dyan. But just want to emphasize na kasali po, covered po nitong penal clause itong manual at saka electronic na pamamaraan ng ating mga procurement processes. Of course, hindi lang po ito sa competitive bidding, kasali po yung mga alternative methods of procurement din. So kaya lahat po ng mga procurement process ay kasali or covered itong penal provisions. Okay? So ano ba yung corresponding penalty, no, sa mga acts na na-enumerate natin kanina, yung general classification, and we will also be discussing further, no, ano po yung mga specific acts o samples nito. So imprisonment po yan, no, for not less than 6 years and 1 day, but not more than 15 years. No, bakit may kasama pang 1 day, no, yung 6 years? Alam naman natin, no, kasi nga sabi po ng mga lawyers ay ito po ay deliberately na dinagdagan ng 1 day kasi nga para may mabigyan, no, na makahimas rehas talaga yung mapatunayang nagkasala, no, sa ating mga provisions or nakabiolate ng mga penal provisions na ito. And of course, kung may 1 day po yung 6 years, may additional 1 day, wala po daw kasi yung probation. So hihimas rehas talaga po yung ating mga convict. Imprisonment, meron pong temporary or perpetual disqualification from public office, no, kung ito ay public personnel or public employee, no. So depende po yan sa appreciation ng kaso sa korte and of course ng judge kung bibigyan po kayo ng temporary or perpetual na disqualification to return to public service, no. So definitely malaking impact, no, sa lalong-lalo na sa mga breadwinners or may yun lang po yung kanilang pamamaraan ng livelihood, no, yung pagtatrabaho sa public service. And of course, yung permanent disqualification from transacting business with the government, no. So take note, permanent yan, hindi po yan walang temporary. As far as private individuals are concerned, hindi po sila pwede nang makapagnegosyo with the government once they are found guilty, no, of this violating these penal provisions ng RA 9184. So jokingly, alam naman natin sinasabi nila na RA 6115 yan dahil na 6 years and 1 day at not more than 15 years, no? So yan po yun na nakalagay dyan. Okay? So take note, yung jurisdiction naman, no, jurisdiction over the offenses defined under this rule shall belong to the appropriate courts according to laws existing at the time of the commission of the offenses. So depende po yan kung kailan po na commit po yung particular offense at yung jurisdiction naman depende po naman yan, no, kasi nga meron tayong iba-ibang klaseng courts, no, sa ating judicial system. Meron tayong regional trial court, meron tayong court of appeals, meron pa nga tayong sandigan bayan, of course meron tayong Supreme Court, and of course nandyan pa yung ombudsman, no? So medyo malawak kasi ang ombudsman, ang authority o yung mandate na binigay sa ombudsman natin, no. So meron silang quasi judicial, no, na function. So para din silang korte, although they are under the administrative or executive department, pero meron silang binigyan po sila ng batas ng quasi judicial na function. Kaya pwede po din, no, pwede po din silang magpataw ng mga corresponding sanctions or penalties, no, once na napunta po sa kanila ang particular kaso about RA 9184 na mga violations, particularly the penal provisions, no. So yan po yung mga possible na mga mapupuntahan na mga jurisdiction. So when we say sandigan bayan, parang meron yung salary grade, no, yung salary grade 27 pataas yata excuse na mga government personnel or officials, no. So doon po mapupunta yung kaso sa sandigan bayan. So kung merong mga nadamay, no, kasama mga access mga kasabwat, no, ng mga mababang mga sweldo or salary grade, damay-damay niyan, punta yan sa sandigan bayan lahat kasi hindi naman pwedeng ihiwalay, no, yung pag-try ng case niyan. So kung may nadawit na salary grade 27 na official, public official, and then meron ding mga kasama niya na below salary 27, isa na yan, punta na yan doon sa ang jurisdiction sa sandigan bayan. So yan po yun. Okay? Now ito po yung mga specific na mga offenses, no, na nakalagay sa section 65.1 of the implement, lalo na yung mga back secretariat kasi sila po yung merong custody, no, ng mga submissions, no, yung mga proposals ng ating mga prospective bidders or mga bidders natin, no, sila po yung custodian ng bid box at sila din po most likely ang custodian ng mga accounts, no, sa online accounts. Doon po nilalagay yung sinasubmit yung ating mga bids, no. when they prefer to submit it online, yung ating mga bidders. Kaya very careful dapat tayo na hindi mabuksan ito, no, on or before ng ating or before the stated or stated time, no, ng ating nakalagay sa bid docs natin or bidding documents, no. So hindi po pwedeng mabuksan yan unless officially open, no, by the authorized official or procurement official. Kaya kung merong mga incident na gano'n, no, accidentally nabuksan, lalong-lalo sa manual, no, kasi nga minsan hindi yan na-seal properly, and then pag bit-bit, no, ng ating back secretariat during sa bid opening ay bukas na, so posible po kayo ay madawit dyan or pagdudahan, no, ng ating mga bidders na binuksan nyo or sinilip nyo. So kaya very careful dapat tayo dyan. So to ensure na hindi tayo masabit, no, kasi yung mga bidders natin minsan naghahanap lang yan ng mga pamamaraan para makapasok talaga, no, makuha nila yung kontrata kahit hindi naman sila karapat-dapat. Okay? So another possible offense itong delaying, no, without justifiable cause the screening for procurement processes. I'm sure that it was already emphasized to you na once na we are designated as a Bids and Awards Committee member, secretariat, chairperson, no, o TWG, or even end user provisional member, no, kasama po lahat na dapat jury duty tayo dyan. When we say jury duty, no, we focus or we give primary attention, no, or focus to the procurement activities over, no, our regular function. Alam naman natin karamihan sa atin, designation lang ang ating membership sa Bids and Awards Committee and Secretariat, no? Kukunti lang yung organic na secretariat. So sila po, no, itong meron talagang mga primary na mga function yan, no? O meron niya mga positions na ginagampanan na function related to their mandate. Pero dahil nga ito naman talaga yung procedure natin, ito po yung nakalagay sa batas, we designate, no, personnel with integrity and so on and so forth na may capacity, no, to undertake procurement process. So yun po, kailangan tutukan pa talaga natin ang procurement kasi nga kaya nga ito nilagay talaga sa RA 9184 itong jury duty na requirement kasi nga ang general welfare ang tinitingnan dito. Once na ma-delay kasi yung mga projects natin, no, ay madidelay din ang impact nito. Malaki itong negative impact nito sa ating mga beneficiaries, no, na makaka-benefit itong project or itong mga programs nating or mga activities na ating gustong i-deliver sa kanila. No? Kaya very important na we prioritize, no, the procurement activities over posible po kayong makasuhan, no, o violating this particular requirement of law. And then unduly influencing or exerting undue pressure on any member of the BAC or any officer of the procuring entity. So ito po yung sabi natin kanina, yung coercion, no? So when you threaten, no, or you pressure someone na nasa BAC, no, na involved sa BAC for procurement activities or procurement processes in order for you to gain, no, something, favor ba or sa iyong mga kamag-anak or kaibigan, no? So bawal na bawal po 'yan. Unduly influencing or exerting undue pressure. Even the Hope, no? Kung Hope mismo ang gumagawa niyan, definitely sabit po siya diyan. Sabit po siya sa itong provision na ito, no, ng ating penal provision. So hindi po exempted ang ating Hope na pag-i-influence siya kasi nga dapat maghintay lang siya, no, sa ano po yung i-recommend at saka po siya mag-decide whether to approve or disapprove, no, yung rekomendasyon ng Bids and Awards Committee sa kanya. No, hindi po siya pwedeng mag-pressure, no, lalo na to influence, to provide favor to someone, no, sa kanyang kakilala. And of course, splitting of contracts, generally speaking, hindi talaga pwede yung splitting of contracts kasi nga lalong-lalo na kung when we are the intention, no, our intention is to circumvent certain rules and procedures ng RA 9184 and its implementing rules and regulations, including GPPB related issuances. No? Pero kung meron naman tayong intention ay kung if ever, no, ating intention naman is to maximize, no, the competition and to provide level playing field sa lahat, then pwede naman na yung mag-split ng mga contracts into small packages as long as we don't violate, no, the rules and procedures, and we don't have the intention to circumvent certain laws, rules, and regulations. So yan po. So generally speaking, bawal po yung splitting of contracts. Of course, meron niyang mga exception. Okay? So tingnan lang natin yung intention. So kung yung intention mo ay to circumvent certain rules, tulad ng pag-conduct ng public bidding, china-chop mo ng mas maliit, yung mga ABC, para hindi kayo lalampas sa threshold, then that would be a violation na, no, of the provision, and pa-fall po yan sa splitting of contracts na pinagbabawal. Okay? And then when the head of the agency abuses the exercise of his power to reject any and all bids, no? So ito rin, no? Alam naman natin na recommendatory lang ating Bids and Awards Committee as to the procurement opportunity na ibibigay, kung kanino ibibigay o i-award ang kontrata. So kung inabuse naman ito ng Hope, no, yung kanyang power, no, to reject, no, or accept the bid, ay depende po yan, no, sa circumstance. Kasi meron naman, allowed naman talaga ang Hope when on justifiable reason, no, i-reject na yung recommendation ng BAC, or mag-declare ba ng failure ng bidding, if ever, na mag-fall yun sa Section 41, yung reservation clause. No? Yung sinasabi natin na when isa sa mga nakalagay doon ay yung mga Bids and Awards Committee ay hindi po sumunod sa mga required na mga procedures. So nakita niya na hindi po sumunod, and then pwede po niyang i-cite po yung reservation clause at mag-declare po ng failure of bidding at ipaulit, no, itong mga processes. Or pwede din siya mag-reject ng bid kung nakita niya na mayroong anomalya or mga prima facie evidence, no, to show na may collusion among the BAC members, no, na may pinapaboran, no. Pwede din yan actually, no. So pwede niyang kung may mga ebidensya siya, no. Pero other than this, the mga justifiable reason, kung sa tingin niya kung meron lang talaga siyang pinapaboran na mga kaibigan, no, na gusto niyang bigyan ng kontrata kahit hindi naman qualified or hindi eligible o hindi talaga the lowest calculated responsive bid or the highest rated responsive bid as recommended by the BAC, then pwede po siyang makasuhan. And then if found guilty, then hihimas rehas po talaga ang Hope nito. Okay? So yan po yung mga possible offenses, no, na pwede makumit ng ating mga public servants. Now, let's proceed with the private individuals naman, no. Ano po yung mga offenses na pwedeng makumit nila? Ito nakalagay sa Section 65, point 2 and point 3, or 65B ng RA 9184. So ito po yung agreements and submission, no, of bids with pre-arranged lowest bid, no. So ito po yung sinasabi nating collusion kanina, no, yung nag-uusap-usap yung dalawang or two or more, no, na mga prospective bidders na mag-uusap-usap sila na kunwari, no, magsasubmit sila ng mga bids, pero alam na nila kung kanino posibleng mapupunta yung award, kasi nga yung na pag-usapan nila sino magsasubmit ng ganitong amount at sino po yung pinakamababa. Assuming lang, no, na sila talaga yung yung mga nag-collude among themselves ay magiging mapipili sa isa sa mga lowest calculated bid, no. So hindi naman necessary ganyan, pero at least, no, kung meron talagang mga pag-uusap at mayroon tayong mga ebidensya to prove this, then we might as well file this, no, in a proper courts or authority to decide. But generally speaking, bawal po talaga yan kasi nga it would defeat the very purpose of doing the procurement process or the competitive bidding or the alternative methods of procurement, no. Kasi nga we want the best value for the best price, no, na ating pibighin. Kung merong mga ganito pag-uusap, so wala na yan, parang na-defeat na yung purpose. Okay? Ito po, agreement to secure undue advantage, no. So meron po mga connections, kunwari, no, itong isang bidder sa loob, no, ng procuring entity. So mayroon siyang mga undue advantage na nakukuha, such as mga information, no, kunwari may if ever may nakasilip, no, na bawal yan yung pagbubukas ng mga bids before the date, time, and place, no. Pero kung mayroong mga ganyang pangyayari, no, may nakakasilip kung ano yung bid na na-submit ng isang kalaban niya, no, and then may information na nabigay sa kanya, undue advantage yan, no, na secure niya, which is a violation, no, or offense that is prohibited. And then yung malicious submission of different bids through two or more persons, no, kasi dapat isa lang, no, kung masasali man tayo sa public bidding ay dapat isa lang yung ating offer, hindi pwedeng dalawa or more, na ino-offer natin. Parang raffle entry yan na the more entries you send, the more chances of winning. Hindi po pwedeng ganun. No? Isa lang po talaga ang ating pwedeng isubmit dyan. And then kung may ebidensya na ganito ang ginagawa ng isang particular bidder, then masasabit po siya dito at makakasuhan and then eventually makukulong if ever found guilty. Okay? Employment of scheme disadvantageous to the public. So ito po yung general no na statement or violation, no, if ever kahit anong mga schemes na or kahit anong mga pamamaraan na magre-resulta no sa disadvantageous na contract ang mapasok sa ng gobyerno, then that would fall under this particular provision or offense. Okay? Nakalagay po diyan sa baba, public officers conspiring no with the private individuals are also liable under this particular provision. So kung mayroong mga kasabwat, kasi mayroong mga offense dito na kailangan na may kasabwat sa loob no ng mga public officials or employees or personnel sa procuring entity bago makomit itong successfully makomit itong mga offense na ito. Kaya sasabit din po sila sa provision na ito. Okay? Ito naman yung mga other no mga offenses na makukomit din ng mga private individuals no under the section 65.3 or 60 of IRR and section 65C of RA 9184. Okay, so ito po yun. Submission of eligibility requirements containing false information or falsified documents or concealment of such information. No? So, when ito po kasi ay when two or more bidders agree no and submit different bids as if they were bona fide no when they know that one of them was so much higher than the other. So yan po yung mga corresponding na mga offense no na ginagawa dito. And of course, magpo-fall po itong submission of eligibility requirements containing false information. Ito po yung nakalagay kanina sa misrepresentation, no, yung fraudulent practice na tinatawag natin as discussed earlier. No? Submission of bidding documents containing false information or falsified documents or concealment of such information. So titingnan nyo parang pareho lang yung dalawang offense, pero titingnan yung much deeper, iba po yan. No, kasi yung kanina, eligibility requirements. And yung pangalawa ay mga other na mga requirements sa bidding process. So not necessarily eligibility lang, kundi yung iba pang mga documents na sinasubmit no, or nire-require ng ating bidding documents. No? Kaya magpo-fall din yan dyan. So not only the eligibility requirements, but also other relevant documents na pinapasubmit sa ating mga bidders. Okay, so kung falsified yan, yung mga peke, yung mga dinodoktor, no, nakukuha lang sa, meron pa bang recto ngayon, no, ganon, so bawal na bawal po yan. Okay, so using name of another or allowing another to use one's name, so bawal din yan, no, kasi alam naman natin when they applied for the SEC registration, when they applied for the BPI registration, BIR, so alam naman natin na o mayor's permit, ay binibigay lang po yung authority sa paggamit niyan sa mga may-ari po talaga. Hindi pwede yan ipahiram sa iba. No? So when they allowed it for others to use one's name para lang makapagpasok sa negosyo or makapagawa ng kontrata sa gobyerno, then that would be a violation of this provision and it would fall under this offense. Okay, so yung withdrawal naman of bids, no? Generally speaking, pwede naman talagang mag-withdraw ng bid, no? Even modify it, no, before the deadline for submission of bids. Pero kung paulit-ulit naman itong ginagawa, no, habitual na withdrawal, then that would be a violation. Ito po yung ibig sabihin nito, no, withdrawal of bid, yung habitual na withdrawal, no, yung intention lang niya ay para ma-offeran siya ng ibang mga bidders na bibilhin yung kanyang offer or i-offer yung kanyang bid na para mag-withdraw siya para manalo yung iba, no, or mapagbigyan yung iba, then that would be violation. No? Yan po yun at gusto nating iwasan. Yung sumasali lang for the sake of to have an opportunity, no, na mabigyan siya ng offer ng ibang mga bidders na interesado talaga sa kontrata. No? In other words, nagpapabili lang siya ng kanyang interest, no, or mabibigyan siya ng interest ng iba, no, para mag-withdraw para sila na po ang sumali or sila na po ang manalo sa kontrata. Okay, so bawal na bawal po yan. So again, the public officers who who participated, no, or who conspire with these private individuals in committing these acts would also be liable, no, sa provision na ito. Kaya ingat-ingat po dapat tayo. Okay? So I think we are down again to another knowledge check, Ma'am Monique.
Yes, Director Ricky, that's right po. No? For our second knowledge check question, kindly answer again po through the pop-up poll that shall be flashed in our screen. So for our question po, there you go. Is non-submission or delay in submission of documents for the final awarding of contract considered automatically as withdrawal of bid? Letter A, yes, or letter B, no, and must first be proven to be without justifiable cause. Quick reminder po again, if you have questions, please drop them in through our Zoom chat box or Facebook Live comment section, as our resource speaker shall address all related questions during our open forum. All right, so presently we have 15% of our Zoom participants are currently answering our Zoom poll. So again, no, is non-submission or delay in submission of documents for the final awarding of contract considered automatically as withdrawal of bid? Is it yes or no, and must first be proven to be without justifiable cause? All right, so let us have the results, please. All right, so Director Ricky, we have 81% who answered no, a yes, and 19% who answered no, must first be proven to be without justifiable cause.
Okay, parang nalito yata sila Ma'am Monique, no, sa ating knowledge check question. Kasi nga 81%, no? So 81% ay nalito kasi nga ang tamang sagot nito ay no, no, must first be proven to be without justifiable cause. So although nakalagay po sa atin na-present po natin kanina na withdrawal of bid is one of the prohibited act, no? And it will be violation of a provision, no, yung penal provision natin. Pero that's kung wala namang justifiable reason. Yan po 'yun. Kasi nga meron talaga, allowed naman talaga yung withdrawal of bid for some reasons, no, na allowed under the law. So one of which kung kunwari, no, during sa pagsubmit mo ng bid o proposal ay sa tingin mo kaya pa naman, no, ng inyong entity, no, to serve the contract or to implement the contract, pero it turned out during sa post qualification or during sa evaluation ng bid biglang may extraordinary event na nangyari. Kunwari biglang nagmahal yung semento, biglang na-bankrupt kayo, no, or biglang na-realize nyo na hindi nyo pala kaya, no, to implement the project if ever it will be awarded to you, then the bidder may actually withdraw that with justifiable reason. Meron lang siyang of course penalty na ma-impose sa kanya tulad ng bid security niya, no, mapo-forfeit yun. Pero justifiable yun ng mga case. So hindi po automatic. So ang gusto lang natin emphasize dito na hindi po automatic once na na-withdraw ang isang bidder ay violation na po yan, no, ng ating penal provision. Kung hindi, kailangan without justifiable reason. Yung lalong-lalo na yung na-emphasize ko kanina, yung habitual withdrawal, no? Kasi meron parang threshold diyan at kung at least 3 times, no, na withdraw for a certain period of time for a year, particular year, then posible yan na nanggugulo lang, no, itong bidder na ito sumasali lang for the sake of makakuha ng offer, no, from other bidders for that particular contract or opportunity. So the answer should be no, kasi nga dapat without justifiable reason. Okay?
Thank you very much, Director Ricky. So to proceed po, no, we will be having 19 slides for the final part of our lecture discussion under Learning Session 1. So back to you po, Director Ricky.
Thank you, ma'am. So we'll proceed now with the remaining, no, slides for this module. So we'll go to the civil liability na ngayon. So natapos na po tayo sa criminal, no, na mga offense, possible criminal liabilities if ever we were able to we committed or we will be committing those offenses na na-discuss natin earlier. So alam naman natin na three-prong consequences, no, ang ma-encounter natin or penalties ang ating ma-impose sa atin or sa mga private individuals if ever na ma-found guilty by appropriate authority or the courts, no. So tapos na po tayo sa criminal or penal liability. So we'll proceed with the civil, no. Ano ba po itong civil liability? Ito po basically ay restitution, no, for the damage done and forfeiture in favor of the government. So without prejudice, no, to the administrative, i-discuss natin mamaya, no, yung administrative sanctions that may be imposed in proper cases, conviction under the Act and these implementing rules and regulations of RA 9184 or even RA 3019 or the Anti-Graft and Corrupt Practice Act shall carry with it, no, civil liability, which may either be these two, no, yung restitution for the damage done or forfeiture in favor of the government or even both, no. Depende po yan sa appreciation ng korte, no. Kung meron definitely meron naman talagang damage na incur, no, ang government diyan. So definitely yun po yung i-restitute, no, ng ating mga convicted na mga personnel, no. So even the private individuals, and of course forfeiture in favor of the government kung meron namang na tanggap, no, na mga benefit, na unwarranted benefit, no, itong mga individuals na ito. Kung wala naman, so wala pong forfeiture in favor of the government. Pero kung meron, then isasali po yan, no, ng korte as one of the penalty sa civil liability. And isa dito sa example nito, if ever na tumanggap kayo ng pagkain, no? Yan, very simple, pagkain lang kasi nga nanalo yung isang bidder, binigyan kayo ng pagkain, no, as a form of a pasalamat, no, and tinanggap nyo, and kinain nyo. O, paano yun ipo-forfeit ng government? Nakain na. May corresponding yan, may corresponding monetary value na i-impose yung korte, no, para maibalik yun, no. Kasi nga hindi pwede dapat in the first place na tumanggap kayo noon or if ever na nakatanggap ng suhol, no, particular individual, and then para mabigyan ng pabor ang isang kaibigan and then bigyan ng kontrata, yung particular na suhol na yun, if ever nagasta na, ibabalik talaga, ipo-forfeit yun, no, in favor of the government, no. So yan po yung mga consequence, no, with this particular provision, itong corresponding civil liability. Okay? So we'll proceed. Very simple lang yan, no, civil liability. Kasama po talaga yan, no, sa ating mga penalties. So administrative, no, sanctions. So basically, ang administrative sanction would be suspension, no, ang tinatawag nating suspension sa ating mga bidders, so contractors, supplier, manufacturer, distributor, consultants, no. Kung first offense yan, suspension, no, to participate in public bidding, meaning the whole government for 1 year. Kung second offense, 2 years, no, from participating in the bidding process or procurement process as a whole. Hindi lang public bidding yan, no. Lahat po ng mga procurement opportunities ay hindi po siya pwedeng sumali kung found guilty of violating those acts, no, na violating or committing those acts, no, na present natin earlier. And then disqualification from further participating in the public bidding being undertaken by the procuring entity, no, kasi merong minsan na suspension muna, no, sa particular procuring entity until such time na ma-proven guilty na talaga or ma-found guilty of violation. So interim, no, interim penalty ito tawag natin, i-discuss natin ito mamaya. Itong suspension for a particular procuring entity lang, hindi sa whole government. And another administrative sanction yung forfeiture, no, of bid security or performance security, no. Kasama po yan sa administrative sanctions. Kasi nga alam naman natin na nagre-require tayo ng posting itong bid security at performance security to ensure that the government has a hold, no, merong pagkukunan ang gobyerno once na nag-violate or may mga na-commit itong mga sumasali sa atin sa procurement, no? So during competitive bidding stage, ito bid security ang mapo-forfeit. Pero kung during contract implementation stage na, then itong performance security ang correspondingly mapo-forfeit for violating certain provisions of the contract, no? Yan po. And lastly, yung blacklisted, no? Pwede po silang ma-blacklist kung dumaan na po sa proseso and then nakita po talaga na karapat-dapat silang i-blacklist, then yun po ang corresponding penalty, administrative po tawag dyan. No? Yung mabablacklist sila for a certain period of time, yun nga, yung hindi pwedeng sumali for first offense 1 year, to second offense 2 years, and then so on, in number of offenses multiplied by 2. Yan po yun. Sa whole government po yan, no, na mga opportunities. So malaking dagok din yan, no, sa ating mga bidders, considering na malaki naman talaga ang opportunity to do business with the government. No, kung tama lang ang pamamaraan ng ginagawa natin. Okay? Now let's proceed to the liabilities under RA 3019, no? Yung ating Anti-Graft and Corrupt Practices Act. So 1960 pa ito na batas, pero until now it's still very relevant, no, sa ating mga gawain dito sa publiko. No, kaya dapat nating i-discuss ito kasi we are talking about procurement, no? And this law is very relevant, no, to RA 9184. Kaya kailangan nating isali dito sa ating module itong RA 3019, Anti-Graft and Corrupt Practices Act. Yung mga certain provisions lang naman, no, nakaka-apekto. So first, section 3A, no, of RA 3019, yung persuading, inducing, influencing another public officer, no. At letter A, number 1, to perform an act constituting a violation of rules and regulations, no. So yun po, yung sabi natin kanina, yung nagpe-persuade ng isa doon yung nagko-coerce, no, na tinatakot or even harming, no, yung ginawa na talaga yung pag-commit ng pananakit, no, sa para lang makakuha ng opportunity or mabigyan ng pabor ang isang individual, no. So bawal na bawal po 'yan. So covered po 'yan ng itong batas na ito, hindi lang RA 9184. Yung pangalawa naman, yung allowing himself to be persuaded, to be so persuaded, induced or influenced to commit such violation or offense. No, so sila hindi lang po yung nanakot or nananakit ang sakop dito, kung hindi kasama po yung nagpatakot o yung natakot at gumawa naman at sumunod sa mga inuutos ng nananakot sa kanya. So hindi lang po yung so in my example earlier, yung supervisor na nanakot sa kanyang subordinate na kasali sa procurement process na gawin itong mga acts na pinagbabawal, kasama po yung subordinate na natakot naman at ginawa at sinunod, no, ang utos ng kanyang supervisor na gawin yung mga violation o yung mga acts na yon. So although hindi siya covered ng RA 9184 na penal provision, pero in this case kasali po sa RA 3019. So sasabit din siya at when found guilty, then hihimas rehas din siya as we will be discussing later. Ano po yung penalty sa mga violations nitong mga acts nito na pinipresent natin sa Anti-Graft and Corrupt Practices Act. Okay? So very careful dapat tayo, ha. Hindi tayo pwedeng matatakutin kung tayo ay involved sa procurement process kasi nga nakasalalay dito ang ating dignidad, no? At posible po tayong madamay sa kaso. Okay? Next is the section 3B, no? Yung directly or indirectly requesting or receiving any gift, present, share, percentage, or benefit for himself or for any other person, no, in connection with any contract or transactions between the government and any other party wherein the public officer in his official capacity has to intervene under the law. So medyo mahaba yan, but basically ang gusto lang i-emphasize nito ay bawal po, no, na ang magtanggap whether directly or indirectly, no. Tinanggap mo directly, binigay sa iyo, tinanggap mo, or indirectly, no, hindi mo naman tinanggap pero iniwan sa iyo and then naka-benefit yung ibang tao na kakilala mo, kayo ka-office mate mo, no. So ganon, kasali po 'yan, no, sa mga pwedeng makommit ng ating mga public officers and employees o personnel, no. And then yung pagtatanggap ng mga benefit o share kasi nga nanalo yung kaibigan mo sa certain contract and then nakasama ka doon sa procurement process, na pasasalamat, binigyan ka ng persento, no, ng contract, yung profit niya, no. So bawal na bawal po 'yan. And then of course in this example, yung sabi ko kanina, yung gap, yan po ay masasabit sa provision na ito. So very careful dapat tayo. No? In fact, as much as possible, no, we impose no gift policy sa ating mga opisina to avoid this particular situation from happening. No? Kasi when we issue a policy for this, wala na. No? Very clear na kahit anong kaliit yan na gift ay hindi talaga pwedeng tanggapin. No? So to ensure na we abide with this provision. And of course, meron naman yan sa RA 6713 pero hindi lang masyadong clear, no? Kasi may parang exception yan doon sa RA 6713 yung mga kung gaano kalaki or gaano kaliit ang isang gift na pwedeng tanggapin o hindi. So parang ganoon. So in this case, when we issue no gift policy, absolute yan dapat, no gift policy ang i-enforce ng opisina to avoid this situation from happening. Okay? So next, itong section 3D, accepting or having any member of his family accept employment in private enterprise which has pending official business with him during the pendency thereof or within 1 year after its termination. So ito, maraming hindi alam ito, no? Bawal pala. Pero unknowingly, nakaka-violate na pala tayo, no? In this particular provision. So very careful dapat tayo, especially so kung tayo ay involved sa procurement process at meron tayong hand, no, sa pag-decide, no, ng mga sitwasyon na ito. So in this case, a good example of this, meron kayong kasama po kayo sa Bids and Awards Committee, no? And then yung anak nyo ay pumasa sa bar exam at nag-top, no, top 1, no? Say for example, at ang nanalo naman na contractor ay isang malaking contractor at may kontrata ongoing with your particular procuring entity na yung yung anak naman ninyo ay gustong mag-apply, no, sa itong malaking korporasyon na ito. Kasi nga top 1 siya, so definitely or kahit hindi siya nag-apply, no-offer sa kanya yung posisyon, no, ng particular corporation na ito na may kontrata ongoing with your procuring entity, no. So hindi po pwedeng tanggapin ng inyong anak yung offer na posisyon sa korporasyon or business na ito. Even after 1 year, no, of the termination of the contract. So yan po, very careful dapat tayo dyan. No? Kasi it would be somehow parang hindi naman necessarily naka-influensya kayo, pero hindi kasi may very clear prohibition ang batas, no, itong RA 3019 sa mga gawain na ito or sitwasyon na ito. Kaya we should ensure na hindi tayo makabiolate, no? Kaya very careful dapat tayo sa ating mga desisyon. Okay? So, pero after 1 year naman, and then nandun pa rin yung opportunity, then pwede nang tanggapin ng inyong anak. But within 1 year upon termination, hindi pa rin pwede. No? Lalong-lalo na kung ongoing yung kontrata, no, ng ng korporasyon na ito. Okay? So I hope that's clear. So we'll proceed to the next provision. Itong Section 3E, causing any undue injury to any party, no, including government, or giving any private party any unwarranted benefits, no, advantage or preference in the discharge of his official, administrative, or judicial functions through manifest partiality, evident bad faith, or gross inexcusable negligence. No, so medyo malawak din ito. Kahit anong injury, no, na experience ng isang even bidder, no, kasi hindi lang sa government yan, kasama yung mga prospective bidders natin o yung mga bidders, no, lalong-lalo na yung mga bidder, no, yung mga natalo, disqualified na mga bidder, hahanap yan ng mga pamamaraan para ma-qualify sila ulit or mapagbigyan sila mga alanganin, no, ng mga acts ninyo at pwedeng magamit, no, sa mga kaso, no, to give them yung masasabi nga nating undue injury, no, sa any party. Kasi nga yun po pwede po nilang gamitin sa pagkaso sa inyo at mahirap pa naman, no, mag-entertain ng mga kaso na yan, no. Mahirap dumaan sa proseso na yan kahit hindi naman talaga tayo guilty, pero sa the fact na nakasuhan tayo, hassle na yan on our part. So we should be very careful, no, in order for us to avoid this situation. Yun nga, undue injury, no. Yun din mga unwarranted benefit, no, na binibigay ng isang official, no, sa mga ibang mga bidders to the point na na nakaka-benefit or may advantage na nakukuha, no, isang bidder na hindi naman karapat-dapat, no. Kasi nga dapat equal opportunity, level playing field ang ating binibigay na environment, no, para sa mga procurement processes natin. Okay? So even mga judge, no, kasama po yan dito, sakop po sila kung may mga decision sila na tend to favor certain person, no, to the disadvantage of another, siyempre makakasuhan din sila on their decisions na about procurement. So, or for any other matter, pero we are focusing more on procurement kasi dito, no. So, yan po, kasama po sila dito. Okay? So, yan po yung examples ng ating section 3E. And then the last, no, provision of RA 3019 na gusto nating i-discuss, itong entering on behalf of the government, no, into any contract or transaction manifestly and grossly disadvantageous to the same, whether or not the public officer profited or will profit thereby. So regardless po yan, no, hindi po necessary na kumita po siya, no. O the fact na naging disadvantageous or grossly disadvantageous itong kontrata na pinasok ng isang procuring entity, ay sabit na po siya, no, sa section 3G na ito. Hindi po mag-matter kung kumita po siya o hindi, no. So the fact na grossly disadvantageous yung pinasok ng kontrata. So we should be very careful, no, more particularly the Hope and all those nag-recommend, no, kasama po yan. Kasi kung nakikita na hindi nyo ginampanan ng maayos ang inyong trabaho, no, especially yung mga TWG na tumutulong sa ating kasi mga expert yan sila so dapat they should be able to provide, no, the necessary expertise na guidance, no, sa pag-decide itong mga Bids and Awards Committee. Pero kung haphazard yung kanilang ginawa, walang due diligence na binigay, no, sa kanilang mga trabaho, then it will result to the grossly disadvantageous contract for the government. Patay tayo dyan, no, damay-damay po yan lahat, no? So karamihan dyan yung mga overpriced, no, hindi yung mga end user units ay hindi ginampanan yung mga market study, no, na I hope na discuss yan sa procurement planning, yung market study, market analysis, no, yung feasibility study, no, yung costing natin, no, dapat very careful tayo diyan. Yung project costing dapat tamang-tama lang, yung ating ABC hindi masyadong mataas, no, kasi kung masyadong mataas yan magiging overpriced, no, and then of course the mga bidders would take advantage of that kasi nga profit oriented yan sila so kung mataas yung ABC, siyempre mataas din yung kanilang offer, and once na award sa kanila yung kontrata, then it would result to grossly disadvantageous to the government kasi overpriced nga, masilip yan, damay-damay po lahat, no, maraming mga ganyang mga kaso in the mainstream ngayon, no, as you would note, kaya very careful dapat tayo dyan. Okay, so I believe na-cover na natin itong mga provisions na dapat nating malaman as far as Anti-Graft and Corrupt Practices Act na related, no, sa procurement process natin, related sa RA 9184. So ano ba yung penalty? So the same, no? Practically the same with the penalties na nakalagay sa penal provisions ng RA 9184. Not less than 6 years and 1 day na imprisonment, but not more than 15 years. Although binasa ko yung law sa Ombudsman website, parang nakalagay not less than 6 years and 1 month, no, hindi 1 day. Pero just the same, no, pareho lang yan, more or less, kasi nga kulong din yan, no, himas rehas din tayo dyan kasi nga walang probation kung magsusobra ng additional day after 6 years. Okay, so ingat-ingat po tayo. And then main difference lang itong perpetual disqualification from public office kung RA 3019 ang violation, no, kasi nga walang temporary disqualification dito, unlike sa RA 9184, meron temporary disqualification na pagpipilian itong judge na magde-decide sa ating kaso. But in this case, perpetual disqualification talaga, no, permanently disqualified na tayo to enter into public office once na convicted tayo with RA 3019. So, yan po. Kasi nga hindi lang limited sa RA 9184 ang pwedeng ikaso sa atin na violation, kundi kasama po yung violation under RA 3019. Kaya po din discuss natin ito. Okay? And then confiscation or forfeiture in favor of the government. Ito mga unwarranted na mga benefit. Yun nga yung sabi natin kanina, yung civil na mga liabilities. Kasama po yan sa mga accessory penalties na may impose sa atin for violating RA 3019 or the Anti-Graft and Corrupt Practices Act. Okay, so I think we are now ready to proceed with the next, no, itong protest mechanism for this module. So protest mechanism, ito po ay alam naman natin na mayroon tayong every now and then may mga decisions tayong pinapasukan, no, na mga resolutions na ginagawa as far as procurement process is concerned, and in any stage, no, pwede po itong i-question, no, gawan ng issue ng ating mga bidders, lalo na yung mga disqualified bidder kasi sila yung na-disadvantage sa mga decisions natin, no. So tingin nila kung meron silang karapatan, no, o meron silang mga dapat erase na mga issues, then they could always resort to this, no, itong tinatawag nating protest mechanism, no, in other words due process, no, entitled to them. So ito po yun, decisions of the Bids and Awards Committee at any, no, procurement stage may be questioned, no, by filing a request for reconsideration. So request for reconsideration in the sense na parang MR din to, motion for reconsideration, kung court proceeding ang pinag-uusapan natin, no? So since this is an administrative proceeding, so mas layman, no, ang ating pagtawag, request for reconsideration. So yan po. So within 3 days, nakalagay po dyan na calendar days, within 3 calendar days upon receipt of the written notice or upon verbal notification, meron pong 3 araw, no, na binibigay sa mga disqualified bidder natin to file a request for reconsideration for any decisions, no, na nagawa ng ating Bids and Awards Committee. So allow me to discuss here more detail kung bakit merong written at merong verbal. Depende po kasi yan, no. You would note na yung presence ng ating mga bidders ay hindi po required or mandatory during opening of bids, di ba? Alam naman natin yan. Na-disqualify sila, then hintay po tayo ng written notice, no? So susulat kayo informing the particular bidder na disqualified po sila, bakit po, ano po yung mga reasons, then doon po magsisimula yung 3 calendar days, magre-recon yung filing of a request for reconsideration. So take note, either written or verbal notification, magre-recon yung 3 calendar days. Then once na comply po ito ng bidder, yung 3 calendar days, nakapag-submit po sila ng complaint or request for reconsideration, then may 7 araw, 7 calendar days ang binibigay sa ating back, no, to resolve this particular request for reconsideration. 7 calendar days lang. No, take note, no? So if the request for reconsideration is denied, the decision of the back may be protested in writing to the HOPTA this time, no, head of the procuring entity. Provided, take note that a prior request for reconsideration should have been filed by the party concerned in accordance with the preceding section, and the request for reconsideration has already been resolved. Okay? So, yan po yung process natin sa request for reconsideration bago tayo pumunta sa protest. Okay? So, dapat dumaan muna sa request for reconsideration at meron ng resolution na lumabas, no, sa Bids and Awards Committee bago po pwedeng pumunta sa protest ang ating mga disqualified bidder or party concerned. No? Yan po. Gusto ko lang i-share sa inyo na as a form of mga nakuha natin mga sharing, no, from yung mga expert na talaga or naka-encounter na nito, no, sa mga palaging nakaka-encounter ng mga ganitong sitwasyon, yung request for reconsideration or even protest. No, sabi po nila, as much as possible, hindi natin uubusin yung 7 calendar days when we decide on something, no? Kasi nga, in the first place, before we decide to disqualify, no, decided to disqualify, no, these mga bidders, ay alam na natin na meron talaga tayong basis, no? Kaya when we receive, no, certain request for reconsideration for our decisions, and we are certain that tama naman yung ginawa natin, wag na nating iubusin yung 7 calendar days, no, para ma-impress natin upon this bidder, yung party, na sigurado tayo sa ating desisyon at hindi po alanganin, no? So kung maka-decide tayo as soon as possible, then that would be better, no? Para hindi na sila mabigyan ng impression na alanganin po yung mga desisyon nila, pwede pa tayo makalusot nito pag mag-file ng protest, no, or mabigyan sila ng opportunity, no, na gumawa ng other na steps, no, for them to gain the contract. Kaya very important that when we are sure, when we are certain na tama po yung decision natin, then bilisan natin din ang paglabas ng resolution sa pag-file na nila ng request for reconsideration. Hindi na natin uubusin yung 7 calendar days. Okay? So yan po yung guide natin or ating sharing. Now, let's proceed to the request, no, for protest na, yung filing of protest, yung mga requisites ng requirement ng pag-file ng protest. Sabi ko nga kanina, kailangan dumaan muna sa valid na request for reconsideration or dumaan muna sa tamang proseso sa request for reconsideration bago po siya pwedeng mag-file ng protest. So, must be in writing through a verified position paper accompanied by a payment of non-refundable protest fee. So take note, babayad dapat siya payment. Magbabayad siya ng non-refundable, non-refundable na protest fee at ibabayaran niya ito in cash. No? Hindi pwede other means, dapat cash yan, cold cash, kasi yan po yung nakalagay sa rules. And then the certificate of against forum shopping, dapat mag-issue din siya niyan ng certificate against forum shopping. Tapos this time, i-address na niya ito sa HOPE, hindi na sa BAC. Kasi yung BAC, sa request for reconsideration lang sila. And then since na may decision na yung BAC, na-denied yung request for reconsideration, then sa HOPE na natin dapat i-address itong protest. And then same calendar days within should be filed within 7 calendar days. Other matters and information pertinent and relevant to the proper resolution of the protest and the certification against forum shopping. No? So take note, embedded na po dito sa verified position paper itong certification against forum shopping. So yan po yung minimum, no, na requirement sa verified position paper. Take note that the position paper is verified by an affidavit that the applicant has read and understood the contents thereof and allegations therein are true and correct of his or her personal knowledge or based on authentic records. So yan po, dapat notaryado po yan at may affidavit po, nakasulat po dyan. No, na yan po mga statements na yan. Ang unverified position paper shall be considered unsigned, produces no legal effect, and the results, and it would result, no, to the outright dismissal of the protest. So ground po yan kung hindi po tinupad yung mga requirement na ito. Ground po yan ng HOPE to dismiss the protest. And failure to comply shall not be curable by a mere amendment of the verified position paper. So dapat yung mga disqualified bidder natin o yung party concerned should be sure na kumpleto, no, yung requisite bago nila i-file itong protest nila. Kasi nga, aside from it is non-refundable, no, yung protest fee ay automatic madidismiss po yan. And then hindi po curable ng amendment, no. So dapat sigurado po sila sa pagsubmit nila ng kanilang mga verified position papers and other documents. So ano ba yung process ng protest resolution? So upon receipt, no, of the denied request for reconsideration within 7 calendar days, dapat i-file po ito ng ating disqualified bidder or party concerned to the HOPE, no, this time to the HOPE na. And then the HOPE shall be given 7 calendar days, no, from receipt of this particular protest to resolve this protest. Take note lang, as earlier discussed, yung verified position paper at payment of non-refundable protest fee ay nandyan. At kung kulang, then pwede nang automatic i-dismiss yan ng HOPE. And then the HOPE should be, the head of the back secretariat shall furnish the bidder with a copy of the decision within 7 calendar days, no, from receipt. So yan po. So dapat ito po yung process na sinusunod sa pag-resolve ng ating protest. Of course, once na hindi pa rin satisfied, no, denied ang protest, na dismissed, so pwede pong pumunta sa other avenue itong ating disqualified bidder. Okay, so any protest taken from any decision treated in RNNT 184 and its implementing rules and regulations shall not stay or delay the bidding process, provided, however, that the protest must first be resolved before any award is made. So take note, ha, na when there is an ongoing, no, request for reconsideration or protest, then tuloy-tuloy lang din ang ating procedure, yung procurement process natin. Meaning kung meron kayong bid evaluation, ituloy nyo lang. Kung meron kayong post-qualification, ituloy nyo lang, no, ang inyong processes. Hindi pwedeng huminto dahil nga may request for reconsideration, may protest kayo natanggap. Hindi po yun pwede. So, kailangan tuloy-tuloy lang. Ang hindi lang pwede ay yung pag-award. No? Hintayin muna ninyo na ma-resolve itong protest bago kayo mag-award. No? So, anyway, 7 araw lang naman yan. 7 calendar days, 7 calendar days. So, hindi naman siguro aabot or lalampas sa 90 days na mandatory period, no, from the opening of bids until the award of contract, yung processes ninyo. So, paghintayin nyo ang 7 calendar days na resolution ng protest at saka resolution ng request for reconsideration. So, yan lang po ang dapat natin tandaan na hindi po hihinto yung process. No? Tuloy-tuloy lang, pero hindi muna kayo mag-award until na ma-resolve yung protest. Okay? So, court actions may be resorted to only after the protest shall have been resolved with finality. Ito po yung sinatawag nating doctrine of exhaustion of administrative remedies. Kasi nga, alam naman natin na ating mga korte ay tambak na po sa mga kaso. So, hindi na dapat makakadagdag itong mga maliliit na mga issue sa kanila. Kasi nga, tambak na yung mga trabaho nila doon. That is why they should should observe this particular doctrine, yung exhaustion of administrative remedies. Baka nga kasi, pwede pa naman ma-resolve sa baba lang, sa administrative matter, sa administrative way, itong mga kaso na ito instead of unduly using or exhausting the time, wasting the time of the courts. Okay, so where the protest was not verified and the protest fee was not paid, respondent was held to have failed to avail of the correct protest procedure before it filed its petition for annulment of the award before the regional trial court. So in this case, dumiretso itong particular na disqualified bidder sa kanyang file ng protest doon sa korte or nag-file siya ng kaso diretso sa korte without going through the process of the request for reconsideration and even the protest. Kaya automatically, mali-dismiss din yan kung dumiretso sila without exhausting all the administrative remedies available to them. Okay? So ito po yung table ng ating protest fee. Through issue po ito last 2012 ng GPPB through a resolution number 5. Ang original kasi o yung pinakaunang protest fee natin ay 1% of the ABC before. Medyo malaki yan kasi nga sabi nga nagreklamo kasi yung mga bidders natin na medyo mataas or medyo nahihirapan sila mag-file ng protest aside from the fact na hindi po ito refundable, mataas pa yung 1% sa ABC, kaya na-rationalize ito based on the feedback from our based sa feedback sa ating mga bidders na gawin naman katanggap-tanggap, acceptable itong protest fees natin. Kaya naging ganito, as the ABC increases, lumiliit yung percentage ng ating protest fee to the ABC. So 50 million pesos and below, 0.75% po yan ang ABC. And kung more than 5 billion yan, pesos ang ABC, then 0.1% na lang ng ABC yung protest fee. So malaki din yan kung computein nyo. So, yan po yun. Okay? So, non-refundable yan. Manalo man sila o matalo, non-refundable po yung protest fee. Kaya dapat sigurado po sila na meron silang grounds for filing a protest. Okay? So, we'll again proceed with the analysis check. Ma'am Monique?
Yes, Director Ricky. Finally, we are down to our third and final knowledge check question for this virtual learning session, for our first learning session for today. And the question is, there you go, the non-payment of the protest fee does not toll the prescriptive period for filing a protest, and it becomes a justifiable basis for the hope not to entertain a protest. Is this true or false? Again, the question is, the non-payment of the protest fee does not toll the prescriptive period for filing a protest, and it becomes a justifiable basis for the hope not to entertain a protest. Is this true or false? Quick reminder po again, in preparation na rin po of our surprise knowledge check question, no, kindly change your name using the required format. And that is your MLGU name underscore your full name for you to actually qualify as our knowledge check winner. Note that last na po ito, no? Last chance na po natin to win. So kaya please rename na po your Zoom names with the required format. All right, sir. 34% of our Zoom participants are currently answering our question. I hope everyone participates po, no, to our knowledge check portions. And finally, we get 100% of your participation for today. Ayan. So, let us have the results, please. All right. 79% answered true, while 21% answered false. Ayan po, Director Ricky.
Yes, although hindi natin ito na-discuss, no, pero alam na alam, tama po yung sagot ng ating mga majority ng ating mga participants. The answer is true actually, no. The non-payment of protest fee does not toll the prescriptive period for filing a protest, and it becomes a justifiable basis for the hope not to entertain a protest. Kasi nga wala namang sinasabi, no, na sa rules, no, na pwede pong mag-toll or huminto itong prescriptive period na 7 calendar days. Kasi within 7 calendar days, kailangan na mag-decide, no, ng ating head of the procuring entity whether to grant the protest or not, no. Kung kasi, for the reason na requirement kasi, no, requirement naman talaga yung ating payment of non-refundable protest fee. In fact, in cash nga ito, and kung hindi po nagbayad, no, itong ating party concern, ay automatic po yan i-dismiss. Ay hindi po hihinto, no, hindi po hihinto yung 7 calendar days na pagbibilang na mag-decide po itong ating hope about the particular protest. So tama po yung ating statement. Okay po.
All right,
so
thank you very much po. And congratulations po to our participants who answered the question correctly. All right. Again, thank you very much, sir. That actually ends our discussion proper for today's first learning session. Again, that was Director Ricky L. Sanchez of the Department of Budget and Management, Regional Office 7. And again, thank you very much, sir, for leading us straight to the point discussion on protest mechanisms and remedies. All right, so at this juncture, before we proceed to our first open forum for today, no, let us first watch a short audio-visual presentation on government procurement. We may likewise utilize this portion po, no, to have a quick or short bio break. No? So thank you all very much and see you all in a short while.
Have you ever wondered how sharing of issued blacklisting orders could be made easier for your agency? Well, with the Online Blacklisting Portal, or OBP, you are only one click away from posting and updating the status of your blacklisted entities and accessing information related to your agency's blacklisting history. Let me give you a quick walkthrough of the new OBP. To register, visit the link flashed on your screen. One registration per PE is allowed and only the official user can request for registration. After the successful registration, an alternate user can be added. Your registration will be validated upon receipt of the documents flashed on your screen. Within 3 days from the effectivity date of the BO, PEs should be able to post the BO by filling out the form in the OBP and uploading the copy of the approved BO. You can simply click on the Update Status tab.
Do you know that procurement is crucial in achieving our society's collective vision of a strongly rooted, comfortable, and secure life in the Philippines? Hello everyone, I'm Billy Bayong. Let me show you how our Procurement Policy Board innovates, adapts, and responds to our changing needs to enhance the procurement system and help the government work for us. An efficient, transparent, and competitive procurement system connects every Filipino to vital services from the government. This can help move more people out of poverty, gain access to better education, receive quality healthcare, and enjoy economic opportunities. These yield greater trust in government institutions and bring the country closer to achieving its national development goals. The Government Procurement Policy Board focuses on simplifying various processes to produce more successful procurement that contributes to the effectiveness and efficiency of the government. The board employs strategies to identify needs and implement projects. It refines and calibrates procurement policies, adjusting to emerging trends based on needs of procuring entities. It creates ways to capacitate practitioners to better manage their procurement processes, monitor effectiveness of our procurement systems, and it adapts to the times, especially during national emergencies. The GPPB has strengthened the procurement process at the earliest stage, the planning phase. The board has issued bidding rules responsive to new laws and policies set by the government. GPPB has also streamlined the bidding process through the use of technology. GPPB has introduced guidelines to ensure timely procurement, especially during a national emergency. GPPB Technical Support Office pioneered initiatives to better assist procuring entities. Simple and competitive, transparent and accountable, monitored by the people. These make for an effective procurement system, responsive to the needs of the people. The GPPB, adapting, responding, innovating for nation building. To know more about procurement, visit gppb.gov.ph.
All right, I hope everyone is back po, no? Again, for more quick guide on government procurement and other related short videos and audiovisual presentation, you may visit our official website at www.gppb.gov.ph. Now, to proceed with the course of our program, Director Ricky, may we respectfully ask for your preference po, because while we are on break, we gathered po, I believe, only one question under our first learning session. Would you like to proceed po with our open forum or to our second learning session para at the end of our learning sessions na po yung open forum natin? Director Ricky?
Okay, so hindi po kasi ako maka-unmute. Okay na po. So, depende po. Sige, siguro atin na lang respond yung ating one question or one clarification.
All right, sige sir. Sige po, let's have the question for our first learning session. Again po, please be reminded that these questions are, all of our questions that will be discussed in our open forum shall be gathered through our Zoom chat box and from our Facebook Live comments section. All right. All right, for our, sorry, Director Ricky, I think we have 3 questions for our first learning session. So to start with our first question, in remote areas, in case of having 2 contracts in one fund, and one was separated to expedite the delivery due to urgency of purchase and time is of the essence, will it be resort to splitting of contract?
As defined earlier, no, or in your previous sessions, I understand na na-define po yung ano po yung splitting na pinagbabawal, no? And the splitting, if the intention of the splitting is to circumvent certain rules and procedures of RA 9184, then that would be a violation. In this particular case, it seems na hindi naman ang intention is to circumvent certain rules and procedures. In fact, gusto lang nito ay to be able to deliver the service as soon as possible kasi nga merong urgency ng particular procurement. So it would seem na hindi naman siya considered as a violation na of the existing rules and regulations, and it will not fall under the splitting of contracts na violative of the law. No? So yan po ang aking sagot, pero depende po kasi sa actual circumstance yan and evaluation din ng procure entity kasi you should ensure na wala kayong binabiolate na rules and regulations. Yun po yung intention ninyo ay hindi po para umiwas sa pag-conduct ng public bidding or other requirements ng laws, rules, and procedures.
Thank you, sir. Moving forward to our second question. Should the verified possession paper be notarized?
Yes, it's a requirement na dapat notaryado ito kasi nga may affidavit na ginagawa or statement, may issue statement ang particular na person or entity sa mga facts na gusto niyang ipa-correct or ipa-resolve sa ating hope. Kaya dapat notaryado po itong dokumento na ito. Kasi kung hindi, then pwede po yung maging grounds na considered unverified itong verified possession paper and pwede maging grounds for dismissal.
Thank you very much, Director Ricky. We're down to our third and I believe our last question for learning session 1. What is the liability on the part of the procuring entity if the documents were found later are falsified?
Meaning, hindi po na-discover siguro during sa post-qualification, and then na-award yung contract. So, ito yung premise ko, ito yung presumption ko sa tanong na ito. So, basically, dapat may due diligence, generally speaking, dapat may due diligence na ginawa itong ating mga Bids and Awards Committee together with the help of the Technical Working Group sa pag-post-qual ng mga dokumento. Lalong-lalo na yung sa lowest calculated bidder kasi sila yung dadaan lang naman sa post-qual, hindi naman yung iba. So later on, pag na-discover na falsified pala, then pwede pa rin. Pero during contract implementation stage na gagawin yung pag-file ng case against this particular bidder na awarded contract, a particular winning bidder sa awarded contract sa kanya, at pwedeng i-rescind yung kontrata. So ang assumption ko lang dito na ginawa talaga, may due diligence na ginawa itong ating Bids and Awards Committee together with the Technical Working Group, pero hindi nga lang nakita or masyado siguro maganda pagkatago o magandang pagkagawa itong falsified na document. And later on lang baka may additional information kayo natanggap na may nag-feed sa inyo yung mga talunan ng mga bidder most likely. So nag-investigate kayo ulit and you found out na falsified pala talaga, misrepresentation ang ginawa, then you can still run against the bidder na nag-submit itong falsified document.
All right, I believe that was our final question under our first learning session on protest mechanisms and remedies. Again, thank you very much, Director Ricky Sanchez. So at this juncture, we are down to the second and final learning session of today's program. So to discuss and share his expertise one more on blacklisting guidelines, once again, let us have our resource speaker, Director Ricky Sanchez.
Thank you, ma'am. So I'll proceed with the sharing of my presentation. Yan, I hope it's already visible. So we'll proceed na with the last session, the blacklisting guidelines. As I mentioned earlier, hiniwalay po ito kasi nga meron po tayo mga bagong mga procedures and bagong resolutions or circulars or issuance na ginawa ang ating or nilabas ang ating Government Procurement Policy Board. Okay, so mas kaya kailangang ihiwalay ito to give emphasis on these new procedures and resolutions. So the objectives of this particular module is that that participants should be able to understand the procedures on imposing administrative sanctions in the form of blacklisting to bidders who committed any of the violations during the competitive bidding or contract implementation stage. So as emphasized earlier, blacklisting po is a form of administrative penalty. hindi po siya magpo-fall sa criminal at hindi rin po siya magpo-fall sa civil liability kung hindi sa administrative penalty po siya nagpo-fall. No? And of course, when we talk about blacklisting, dalawa po yan. No? Pwedeng ma-blacklist. Dalawang stages. No? So first, yung sa ating procurement stage, although competitive bidding stage ang nakalagay dito, pero parang pinalitan na po kasi mas misnomer po yung competitive bidding stage kasi nga kahit alternative methods of procurement ay sakop din ng ating blacklisting procedure. Kaya procurement stage ang ating tawag dito. No? Procurement stage, and of course during contract implementation stage once we have already awarded the contract and we are already implementing. So dalawang possibilities po. No? During procurement stage or during contract implementation stage mangyayari ang blacklisting. And then of course to gain substantial knowledge on the responsibilities of the back secretariat, observers, leaders, and end users or implementing units relative to the issuance and posting of the blacklisting order. So hopefully we'll be able to achieve these objectives after we discuss the module. Okay? So ito po yung outline ng aking presentation, uniform guidelines, atin pong ihimay-himayin yan. And then yung sabi ko nga kanina, may dalawa pong stage po, no? Yung pwede nating may dalawang klaseng procedure po, no? Kasi nga ang pag-conduct ng blacklisting kasi ginagawa po ito during procurement stage at ginagawa rin ito during contract implementation stage when applicable. Okay? So as I've said, may nilabas po na resolution ang GPPB last 2017, no, updating or revising, no, or approving the revised uniform guidelines for blacklisting of manufacturers, suppliers, distributor, or consultant. And then na-approve po ito last 2017 of December 21, pero naging effective po ito September 4, 2018 na. No? May due to publication issue or any other concerns, kaya naging effective to much later time. No? So, pero at this time, ito na po yung ginagamit po natin or nire-refer natin when we are to proceed with the blacklisting procedure. No? Or kung meron tayong gustong dapat na i-blacklist. Okay? The reason behind updating or revising this particular blacklisting procedure kasi nga parang 2004 pa yung pinakaluma, no? Before this. Kaya alam naman natin na dumaan na sa dalawang revisions ang implementing rules and regulations. So kaya dapat naman i-update, no, yung guidelines para maging consistent siya sa latest implementing rules and regulations. Kaya po in-update or na-revise po yung guidelines. Sa government because of the pandemic. So ito rin ay gagawin na rin online yung posting ng ating blacklisting sa portal na ginawa, no, ng ating GPPB Technical Support Office for this. So this was passed or approved last June 25, 2020 and made effective last August 7, 2020. Okay, so I hope kung meron kayong blacklist, ito na dapat yung gagamitin natin na procedure or yung form saka yung manner of uploading the blacklisting order. So we'll first proceed with the definition muna, no, bago tayo pumunta sa mga details. Definition muna tayo. When we say blacklisting, ang ibig sabihin lang nito is that it is administrative penalty, no, disqualifying a person or an entity from participating in any government procurement for a given period, no. So pwede din yan in fact in perpetual, no. So mamaya madalaman natin. So basically, as I've said, administrative po ito na penalty, no, na disqualify natin yung mga nag-commit, no, na mga acts na found guilty, no, convicted na sila, no, or may mga resolution na decision na nag-commit talaga sila ng mga violations na yon at dapat silang i-blacklist. So yung either person or entity, no. Pwede yung natural person or juridical entity, no. When we say entity, juridical entity, ito po yung mga artificial person or entity created by law, no, tulad ng mga corporation, no, ng mga partnership at iba pang mga entities. Okay? So person or entity, blacklisted person or entity who has ito po yung definition ng blacklisted person or entity. A person or entity who was disqualified, no, by an agency or is included in the GPPB Consolidated Blacklisting Report, no. So i-discuss natin yan, ano ba yung consolidated blacklisting report na yan ng JPPB. So once na nandoon na yung pangalan nila, no, nandoon yung person or entity sa itong JPPB consolidated blacklisting report, ay malalaman na po ng lahat, no, na blacklisted sila at hindi na po sila pwedeng mag-participate for a certain period, no, as defined earlier. Suspension, no? Ang suspension naman, ito po ay interim, no? When we say interim, pansamantala, no? Interim penalty imposed for infractions committed by a bidder during the procurement stage, no? Whereby such bidder is prohibited from further participation in any of the bidding process of an agency. So, ang suspension ay, ang nasasakop lang po niya ay yung particular agency na sumali po siya at nasuspend po siya doon. So, meaning hindi na po opportunities. Pero sa ibang agencies, pwede po siyang sumali. No? Kasi suspension lang ito. Ito po ay interim penalty lang. Okay? Habang ginagawa pa yung investigasyon or yung decision. And shall be effective during the period of motion for reconsideration and or appeal and shall terminate only upon final decision by the HOPE or appellate authority. So, i-discuss natin yan mamaya. No? So, yan po yung definition ng suspension. Interim penalty po siya. Appellate authority, no? Department or office or government unit exercising general and or administrative supervision, control over the blacklisting agency. So yan po yung tinatawag nating mga appellate authority. Department level agency shall exercise appellate authority over offices, agencies, bureaus, government units, GOCCs, and SUCs under their jurisdiction. So depende po yan sa kanilang structure. And then blacklisting decisions of government agencies that are not subject to general and or administrative supervision or control of any department, office, government unit shall be final and executory. So in your case, mga LGUs, mga municipalities, hindi po kayo, wala po kayong appellate authority. No, yan po yung sabi ng ating speaker noon, yung ating si Attorney Nogra, yung sa DILG, na wala pong as far as LGUs are concerned, and this provision of RA 9184 is concerned, yung blacklisting guidelines natin, ay wala pong appellate authority yung mga LGUs natin. So meaning to say, for municipalities, hindi po appellate authority ang mga probinsya kung saan po kayo nabilong. No? So although component kayo ng isang probinsya, pero hindi po appellate authority mako-consider ang probinsya as far as blacklisting is concerned. Kasi final and executory na po ang inyong decision ni Mayor, no, sa inyong blacklisting order. So wala na pong i-elevate. Even to the DILG, hindi na po kailangan kasi hindi po considered appellate authority ang DILG as far as LGUs are concerned. No? So final and executory na ang decision ng pag-blacklist sa inyong level pa lang, kay mayor pa lang. So in same manner, sa mga barangays, ganun din. No? Hindi po appellate authority ang mga munisipyo or cities where the barangay belongs. No? So hindi po. And even the cities, no, na under sa probinsya, hindi po appellate authority ang probinsya. And even for the province, hindi po appellate authority ang DILG. So take note po for the LGUs. Okay, final and executory na po ang inyong decision to blacklist. Delisting, no? So when we say delisting, ito po ay removal of a person or entity from the consolidated blacklisting report. No? At sabi ko nga kanina, ito ay available po sa GPPB website, no? Itong consolidated blacklisting report. At hindi naman karamihan, hindi naman forever yung ating blacklisting, no? Meron pong certain period of time yan na nagko-cover sa kanyang kung kailan siya blacklisted. And once na na-serve na po niya ng particular person or entity itong suspension na ito na blacklisting, then kailangan i-lift, no, through a delisting order or a delisting procedure na gagawin ng ating procuring entity na nag-blacklist sa kanya, no? So, to be fair naman, kasi hindi naman pwedeng forever siya blacklisted, hindi naman. Kasi may period lang naman yan, no? Unless na perpetually disqualified talaga siya na as ruled by the courts, no? To be violating certain laws such as the Anti-Graft and Corrupt Practice Act. Okay? Or the RA 9184 for that matter. So, a blacklisted person or entity shall be automatically delisted, no, after the period for the penalty has elapsed. So, we should be very conscious about this kasi nga unfair naman, no, sa ating mga blacklisted entity kung hindi na sila na-serve na po nila yung kanilang suspension. So ano po yung scope ng ating blacklisting? So ito po lahat, no, individuals or sole proprietorship, kasama po yung kanyang asawa, no? Kasi nga alam naman natin kung sole proprietorship isa lang, no? Siya may-ari na po siya ng negosyo, pero kasama po yung kanyang spouse sa blacklisted. Kunwari may ibang negosyo yung kanyang asawa o yung kanyang spouse, husband or wife, then automatically blacklisted din yun, no? Kasi nga may conjugal or may community of property relation yan sila, no? So kung blacklisted ang entity ng husband, blacklisted automatic yung entity ng yung business ng wife, ganun. And then partnership itself and its partners, no? So lahat sila ng mga partners ay kasama sa blacklisted. And then cooperatives itself and members of the board of directors, general manager, or chief executive officer, kasama sa mga blacklisted yan. And then partnership, joint venture, or consortium, so para din yung partnership sa taas. No? And then corporation, a single stockholder, together with his or her relatives up to the third civil degree or consanguinity or affinity, and their assignees, no? Holding at least 20% of the shares therein, each person and the president. So yan po, damay-damay na po lahat yan, no, na blacklist. Once the corporation is blacklisted, yung may hold controlling interest sa iba pang mga korporasyon ay madadamay din, no, sa blacklisting order. Okay? Knowledge check na agad pala. Ma'am Monique, please.
Yes, sir. So at this point po, let us have our first knowledge check question under learning session 2. All right, there you have it. The question is, blacklisting is an interim penalty imposed for infractions committed by a contractor during competitive bidding stage, whereby such contractor is prohibited from further participation in the bidding process of an agency. Is this true or false? Again, the question is, blacklisting is an interim penalty imposed for infractions committed by a contractor during competitive bidding stage, whereby such contractor is prohibited from further participation in the bidding process of an agency. For questions, just the same po, no, just please feel free to drop them in our Zoom chats or through our Facebook Live comment section. All right, so 54%, 56% is currently answering our first knowledge check question under learning session 2. Hopefully, no, yung 44, am I correct? 44% po ng ating Zoom participants would also participate po in our knowledge check portions. All right, so let us please have the results. All right, Director Ricky, we have 86% answered true while 14% answered false.
Yes, parang nalito yata sila or na-misled sila sa statement, no? Kasi almost lahat ng words dyan ay tama except for the first, no, word ay mali. Blacklisting kasi nakalagay. Dapat kasi suspension yan, no? Kasi ang statement ay yan ay suspension po ang tinutukoy, is interim penalty imposed for infractions committed by a contractor during competitive bidding stage or procurement stage, whereby such contractor is prohibited from further participation in the bidding process of an agency. So false po yan na statement kasi nga the statement is about suspension and not blacklisting, no? So as defined earlier, yung blacklisting po ay suspension po yan na for 1 year or 2 years depending po sa offense, no? So participate in the whole government na po, no? Hindi po siya interim na penalty lang sa particular procuring entity. Kaya po false yung ating sagot. Yes, false. Okay po.
All right, thank you, Director Ricky. No, babawi daw po sila because I believe we still have two more knowledge check questions under learning session 2 and for our event for today. So ayan po, ano, so to proceed po, sir, we will be having 9 slides for the next part of our lecture discussion. So back to you po, Director Ricky.
Thank you, ma'am. So bawi-bawi po tayo mamaya. Procurement during blacklisting, during procurement stage na po tayo. So ito po yung isa sa mga ways, isa po sa stage na pwede po tayo mag-impose ng blacklisting at gagamitin po natin itong procedure na i-discuss natin. And of course, i-discuss din natin yung mga acts, no, na sakop na pwede po silang ma-blacklist. And you would know, isa-isahin na natin ulit just to reiterate and to remind us, no, ano po yung mga grounds na pwede po ma-blacklist ang isang entity or person. So first, submission of eligibility requirements containing false information or falsified documents, no. So ito po yung tanong kanina, no, yung, in fact sa ating earlier, at wala talaga silang nakita, then pwede, hindi naman sila maging liable dyan, no. Pero dapat meron documents yan to support ano ba yung mga ginawa nila, due diligence ba, considered ba due diligence ay binigay, no, ng mga procurement officials doon. Okay? So yan po, isa po yan sa mga pwedeng maging grounds for blacklisting a person or entity, no, yung pagsasubmit ng mga falsified documents, yung mga binago, peke, no, kasi nga normally diyan yung mga expired, no, hindi pa sila naka-secure ng renewal, no, ng mayor's permit, ng mga SEC registration or mga PhilJEP certificate, no, hindi pa nila na-renew, no, expired na, and meron ng opportunity, gusto nila sumali, so pinipeke nila ito, ginagawang parang totoo, no, pero may ginawa palang pagtatago or falsification, no? So bawal na bawal po yan, and ground po yan for blacklisting. Not to mention yung mga iba pang mga penalties, no, yung civil and criminal liabilities nila. Okay, yung submission of bids that contain false information or falsified documents or concealment, no, of such information in the bids in order to influence the outcome of eligibility screening or any other stage of public bidding. So as I mentioned, parang similar itong dalawa, but as I've said, eligibility requirements po yung sa taas at itong sa baba ay iba pang mga documents na required during bidding process, no? So kasama po yan yung mga post-qual na mga documents na nire-require, no, during sa post-qualification stage. Okay? So sabit din po yan sila kung mga falsified document yan sinasubmit nila. Okay, refusal to clarify or validate in writing its bid during post-qualification within a period of 7 calendar days from receipt of the request for clarification. So take note, no, na required pong sumagot yung ating mga bidders, particularly yung tinatanong natin for clarification, kasi nga minsan mayroong mga dapat natin i-clarify when we undergo bid evaluation. Sumasagot, no, through this channel. Then after 7 calendar days, then we could always use this na ground, no? Kung hindi sila sumasagot, hindi sila nagka-clarify sa ating mga request, then this may be a valid ground for blacklisting the particular entity. Okay? So any documented unsolicited attempt by a bidder to unduly influence the outcome of the bidding in his favor. So kahit ano po yan, no, general po yan na statement, no? So any documented, no, when we say documented, dapat may ebidensya tayo, no, may document to support na ginawa talaga, no, ng particular bidder itong mga attempts na ito, no, na pag-influensya, unduly influencing the outcome, no, of the bid evaluation, of the procurement process as a whole, no, para siya po ang mapaboran na mabigyan ng kontrata, such as panunuhol, no, or pakikipag-contact, no, sa procurement entity para mabigyan ng information or iba pang mga pamamaraan, no, para makakuha ng advantage to the disadvantage of the other bidders. Okay? So pwede po yan maging ground for blacklisting din. Allowing the use of one's name or using the name of another for purpose of public bidding. So na-discuss na natin ito kanina na hindi po pwedeng ipagamit yung pangalan na in-issue, no, sa particular person or entity ng government agency such as the DTI, the BIR, the LGUs, no, mayor's permit, sa paggamit ng ibang mga pinapagamit sa ibang tao para makapag-participate sa procurement process. So bawal na bawal po yan. So kung na-discover na hindi naman talaga siya actually nag-participate, pinagamit lang po niya at para lang makakuha ng fee, no, or commission, no? So bawal na bawal po yan. Pwede po yung maging ground for blacklisting. Withdrawal of bid, so ito po yung isa sa mga knowledge check natin kanina, no, yung withdrawal of bid. Isa sa mga pinagbabawal yan, pero in general pwede naman siya, pero dapat may justifiable reason. So refusal to accept an award or enter into contract without justifiable cause. So take note ha, dapat without justifiable cause para maging ground for blacklisting yan. After he has been adjudged as having submitted the lowest calculated responsive bid or the highest rated responsive bid. So take note, alam naman natin no, na kaya nga tayo dumadaan sa proseso at require natin sila ng bid security in order to ensure that the government is protected. No? Pag ready na tayo mag-award, dapat tanggapin no, ng ating winning bidder itong award na ibibigay sa kanya. Kasi nga para magtuloy-tuloy na yung implementasyon ng kontrata. And if nag-refuse siya na ayaw niyang tanggapin at na walang reason, no, justifiable na reason, then pwede po siya maging ground for blacklisting. Kasi nga malaki po ang impact nito, negative impact no sa implementasyon ng ating mga projects kasi madi-delay naman ito, pupunta na naman tayo sa next lowest at magpo-postqual na naman tayo and so on and so forth. So very precious po ang time po natin no, kaya very important that we emphasize this, no, impose the particular penalty if ever the bidders commit no, these particular acts. And then refusal or failure to post the required performance security within the prescribed time. So alam naman natin no, na papalitan yung mga bid security ng performance security before we award or before we sign the contract. No? It's requirement yan for contract signing. So kung hindi po ginawa, no, ayaw po mag-submit ng mag-post ng performance security. So parang wini-withdraw na rin niya no, itong kanyang proposal. No? So bawal po yan. Kasi nga, yun nga, epekto kanina, magiging delay o magiging further delay pala sa ating mga implementation. And then all other acts that tend to defeat the purpose of competitive bidding, such as habitual withdrawing no, from the bidding or submitting late bids or patently insufficient bids for at least 3 times within a year, except for valid reasons. No? So ito po yung sinasabi natin kanina na kung so ano po yung sanctions no, na during blacklisting? Blacklisting during procurement stage. So ito po yun. Basically yung forfeiture ng bid security, no? Part po yan sa administrative penalty dahil i-forfeit po natin yung bid security niya. Kasi that's the very reason why we impose no, bid security is in order to protect the government. Like, kung meron mga ganyang kalokohan, so we'll be able to reimburse no, or to provide the protection for the government by forfeiting the bid security. And of course, yung first offense, blacklisting for 1 year, at second offense, blacklisting for 2 years. And enforcement of the bid securing declaration. So take note kasi nga meron na tayong additional na form of security, not just the cash, check, or surety bond, but also the bid securing declaration. Pwede na pong magamit yan no, as a form of bid security. Kaya kung yan po yung ginamit ng particular bidder at na-blacklist po siya, so ma-enforce po natin yung mga penalties na nakalagay sa bid securing declaration, which one of which is the payment no, ng difference between the lowest calculated bid and the next lowest calculated bid. No? And other requirements, other sanctions na nakalagay, which is basically blacklisting no, for 2 years. No, nakalagay po doon. And then without prejudice to the imposition of additional administrative sanctions as the internal rules of agency may provide and or further criminal prosecution. No? So hindi po pwede po yan, kasama po yan. Dapat i-maximize po lahat ng mga penalties na ma-impose ng government sa kanya. No? Kung meron po tayong mga internal rules or internal administrative sanctions na pwede ma-impose, kasama po yun no? Sa i-impose natin sa mga grounds na committed grounds kanina as presented. Okay? So ano po yung ating procedure sa blacklisting during procurement stage? First, sino po ang pwede mag-initiate ng action? So sila po, no? Any bidder, prospective bidder, pwede po. Normally, yung mga disqualified bidder para lang mabigyan ng additional opportunity or sila na baka posible pang ma-award sa kanila, no? So they would be able to they would look for mga evidences or mga acts no na na-commit ng itong lowest calculated bidder no sa para ma-disqualified no or ma-blacklist siya, no? So yan po. Duly authorized observers, no? So kung mga observers natin ay nakakita din, naka-observe ng mga anomalya during sa mga procurement stages, then pwede po yan sila mag-initiate ng action for blacklisting order. And then for issuance of blacklisting order, I mean. And then of course the BAC, no? Division Awards Committee can motu proprio, no? Sila mismo once they discovered certain acts no committed, yung mga grounds na na-discuss po natin earlier ay na-commit po ng ating mga bidders, then they could always initiate it by themselves. Okay? So the BAC notifies contractor in writing upon verification or existence of the grounds. No? So take note, when we say contractor, ito po yung definition niya. Shall refer to manufacturers, suppliers, distributors, contractors, and consultants. So sakop na po lahat yan as far as this module is concerned. When we say contractor, yan na po lahat na po yan sila. Okay? So that a complaint has been filed, that he has opportunity to show cause, that a hearing shall be conducted upon request, and the consequence of being suspended and blacklisted. So yan po ang laman ng notice na ibibigay po no in writing sa ating bidder or contractor, I mean, no. So yan po. So the contractor shall submit its written answer to the BAC with documentary evidence and request for hearing, no, if he so desires, within 5 calendar days yan from receipt of the notice. So take note, walang time extension na binibigay no sa ating contractor na nabigyan ng notice about the blacklisting. Okay? So ito po ay procedure kung hindi po nag-submit ng answer itong contractor natin upon receipt of the notice by the BAC, no, or yes, by the BAC. No, does not submit answer, then the BAC would recommend to the HOPE the suspension of the contractor and the forfeiture of bid security. So within 5 days yan binibigay natin sa contractor. So kung hindi po siya sumagot upon notice of the BAC, then re-recommend na po yan ng BAC na masuspend yung contractor and forfeiture of the bid security. So titingnan naman ng HOPE yan, hindi po yan diretso ministerial, hindi po yan ministerial. May discretion pa rin yan ng HOPE, no? Kasi titingnan niya yung evidence, titingnan niya yung mga grounds, no? So within 15 calendar days from the receipt of the BAC resolution and records of the BAC proceedings, the HOPE determines existence of reasonable cause. No? Kung meron, then the HOPE issues a suspension order and forfeiture of bid security. Okay, kung wala naman, then i-dismiss yan ng HOPE. Ito namang procedure na ito, o illustration na ito, ay kung merong answer na sinubmit po ang ating contractor. No? So the contractor submits answer within 5 calendar days from receipt of the notice from the BAC, and depende rin po yan kung magre-request siya ng hearing o hindi. Kung magre-request siya ng hearing, then mag-schedule po yung BAC immediately ng hearing, no, para mabigyan naman ng due process ang ating contractor. Pero kung wala siyang ni-request na hearing, then the BAC would determine the existence of the fault based on the submitted answer by the contractor, no? So based on the complaint, answer, and the documentary evidence and facts verified by the BAC. So if the BAC found na merong grounds, no, hindi valid yung kanyang sagot, then the BAC would recommend to the HOPE the suspension of the contractor and the forfeiture of bid security. And again, within 15 calendar days, binibigyan po yung HOPE na mag-decide, no, whether to determine pala whether there is an existence of a reasonable cause to blacklist or to suspend the contractor. So kung yes, then the HOPE issues suspension order and the corresponding forfeiture of bid security. Eh kung wala naman, then i-dismiss na yung case. Okay, so the HOPE shall furnish the suspended contractor a copy of the decision immediately, no, after its promulgation, yung 15 calendar days. And then yung effect of decision, ano po yung epekto ng kanyang decision or pag-impose ng suspension. So contractor is suspended upon receipt of the notice of decision. The suspension shall remain in effect during the period of motion for reconsideration and appeal, kasi nga mayroon pang appeal, no, na pwedeng gawin ang ating contractor na suspend based sa decision sa HOPE, and shall terminate only upon reversal of the decision by the HOPE or kung applicable ang appellate authority. No, pero if no motion for reconsideration or appeal is filed, then the decision shall become final and executory after the lapse of 7 calendar days from the receipt i-decide na naman yan ng Hope, no, within 7 calendar days from receipt of the MR or the motion for reconsideration. No? So ano ba yung nakalagay sa MR? No? Dapat within 3 calendar days galing sa pagtanggap no, ng desisyon ng contractor ay na hindi po na-grant yung appeal, then the Hope will issue the blacklisting order na after na process na or na-resolve na ng appellate authority yung appeal. Okay? So take note, the filing of our appeal should be filed within 7 calendar days from receipt of notice. Yung MR naman, 3 calendar days from receipt of notice. So yan po yung mga number of days na dapat nating i-observe. Okay, so Ma'am Monique, knowledge check.
Yes, sir. Thank you po, Director Ricky. Now for our second knowledge check question under our second learning session, please answer through our Zoom chat box because we will again be giving a special token to the first participant who shall correctly answer this particular question. So last, ano na po ito natin, prized question. So please make sure din po that you have the correct name format for you to qualify nga po to become our knowledge check winner. So for our surprise question, there you go. The question is, may a PE conduct necessary modification of the posted blacklisting orders? Is this true? Is this yes or no? Nag-agree po ba or hindi? Again po, the question is, may a PE conduct necessary modification of the posted blacklisting orders? Yes or no? Again po, please answer through our Zoom chat box. Although meron pa rin po mga sumasagot sa ating Zoom polling feature, okay lang po yan. But for you to be able to receive our special token, you have to answer through our Zoom chat box for us to identify, of course, kung sino po yung unang nakasagot po ng tama. Alright, Sir Ricky, sige, tingnan po muna natin yung mga sumagot po through our polling feature. Can we have the results, please? Ayan po, Director Ricky, we have 65% who answered no, while 35% who answered yes. Sige, sir, let us reveal po what is the correct answer.
The answer actually is yes. Kasi nga hindi ko na-discuss yan kaya marami nagkamali. Anyway, i-discuss natin bakit, no? Actually, ang knowledge check na ito is to clarify, no, na pwede talaga siyang mag-modify actually yung procure entity, no, na sinubmit niyang blacklisting order. Anytime na nakita niya na may nagpagkakamali, no, na gawa sila when they issue the blacklisting order. So they can modify that, more particularly yung suspension period siguro, no, baka nagkamali sila ng lagay, baka instead of 1 year lang sana naging 2 years ang nilagay nila na order, no. So any other information na sa tingin nila ay mali, pwede naman nilang i-modify. So allowed po yung procure entity na mag-submit ng modification for that initially issued blacklisting order anytime na na-discover nila na may pagkakamali. So hindi po prohibited na gawin yan. Kasi nga, to be fair to the entity na na-blacklist, no? Baka isa nga doon, sabi ko nga yung period of suspension. Okay po?
Alright, thank you very much po, Director Ricky. So the answer is yes. So do we have our knowledge check winner? From what is registered po in my Zoom chat, ang nakakuha po ng tamang sagot, first is from LGU Caraga, Ma'am Lynette Ibanez Francisquete. Ma'am, congratulations po, no? And I will be asking our event secretariat to validate and verify po kung nanalo na po tayo in our previous winners. But again po, congratulations to you po. Alright, so if ever na hindi pa po tayo nananalo, kindly check our Zoom chat po or email as our event secretariat shall ask for your shipping details. Alright, so to proceed, we will be having po 12 remaining slides, Director Ricky, for our final part of our lecture discussion. So back to you po, sir.
Yes, thank you, Ma'am Monique. So congratulations to LGU Caraga. Kahit hindi ko na-discuss, tama yung nasagot niya at siya pang nauna. No? Okay, so we'll proceed na to the last remaining slides. Dito na po tayo sa blacklisting during contract implementation stage. So nasabi ko kanina, dalawa pong opportunity na pwede po tayong mag-blacklist, no, ng contractor kasi nga depende po yan sa grounds na nakukomit niya, either sa procurement stage ba or during contract implementation stage. So this time we will be discussing during contract implementation stage naman, no, ng mga grounds and the procedures on how we'll be able to blacklist, no, the contractor. Okay, so ito po yung mga grounds. As mentioned, you would notice na pareho lang, no, sa ating na-discuss earlier, yung sa mga acts, no, na posibleng makomit, no, yung mga prohibited acts na posibleng makomit ng ating mga bidders or the contractor, supplier, consultants, or distributor. So yan po. So failure, number one, failure of the contractor due solely, no, to his fault or negligence to mobilize and start work or performance within the specified period in the notice to proceed. No? So once na na-issue na po ng procuring entity yung notice to proceed, ay dapat tuloy-tuloy na, no, yung pag-trabaho, pag-implement ng ating contractor na awarded contract sa kanya. Kung wala siyang ginawa, no, nakatiwangwang lang yung project site, walang laman, no, wala man lang na mobilize kahit isang pala, no, para gawin yung kanilang trabaho, then pwede na yang maging ground for blacklisting, no? Kasi nga kaya nga tayo nag-award ng kontrata, kaya nga tayo nag-implement ng project kasi nga gusto nating mabigay agad ang mga programs, projects and activities sa mga beneficiaries. Kung paano po makaka-benefit or ma-enjoy, no, yung particular project ng mga beneficiaries kung matagal, no, or nagdi-delay or dilidali yung ating mga contractor, meron ng NTP, wala pang ginagawa, no? So pwede po yan maging ground for blacklisting during contract implementation stage. And then failure by the contractor to fully and faithfully comply with its contractual obligations, no, without valid cause. No, kasi alam naman natin sa kontrata marami po yang nakalagay na mga contractual obligations on both sides, no, both the government and the contractor, no, has each individual obligations. Kung meron doon na hindi niya ginawa, no, so wala naman siyang reason bakit hindi niya ginagawa, no, or gagawin. So pwede po yan maging ground, no, for blacklisting, no, even after na may written lawful instruction na galing sa procuring entity, no, na say for example na may may ginawa siyang renovation for your property or your office. And then very clear doon sa kontrata na kailangan yung mga gagamiting mga materials ay ganito, no, yung specifications, yung kinabit niya hindi tama sa specifications, so pinagpapapalit nyo sa may written lawful instruction kayo na dapat palitan niya or to replace, no, the particular item na dineliver niya, so hindi niya ginawa, so pwede po yan maging ground for kasi lawful instruction naman yan, no? Kasi nga part sa kontrata hindi niya ginawa, hindi niya tinupad. So pwede po yan maging ground for blacklisting. And then assignment and subcontracting of the contract or any part thereof for substitution of key personnel named in the proposal without prior written approval by the procuring entity. So generally speaking kasi hindi talaga pwede yang subcontracting, no? Kasi nga kaya nga tayo namimili, no, ng mga in a very tedious manner, pamili natin ng mga contractor to ensure that magaling talaga, no, makaka-deliver siya ng kanyang ating expectations, mako-comply niya yung mga nakalagay sa bidding documents natin na requirements. Kung pinapasubcon niya, no, nasasali-sali lang siya pero binibigay niya sa ibang implementation, then bawal na bawal po yan. Lalong-lalo na kung silent, no? Silent yung ating bid docs na walang nakalagay na allowed yung subcontracting. So definitely kung silent, ang ibig sabihin niya, ang default niyan ay bawal, no? So kung ginawa pa rin niya, then that's a violation. That would be ground for blacklisting. Pero there are instances naman na allowed naman yung subcontracting, lalong-lalo na kung nakalagay sa bid docs na pwede yung subcontracting of certain parts or portions of the contract, then hindi po yan violation, no? So dapat lang titingnan natin, balik tayo sa ating documents, no, kung allowed ba o hindi. But kung silent yan, automatic ang default niyan ay hindi po allowed. Lalong-lalo na kung hindi nagpaalam, no? Pero kung nagpaalam naman at nakita ng procuring entity na justifiable yung kanyang reason for subcontracting certain parts, then hindi po yan violation. Okay? And yung substitution naman of key personnel, no? Kasi lalong-lalo sa mga consulting services, we hire or we evaluate, no, the bid based on the submitted personnel, no? Kaya tinitingnan natin sino ba yung mga experts na nakalagay diyan, ng mga consultants, ng mga galing, no? And kaya nga i-award sa kanya kasi nga based sa evaluation, sa rating ay mataas ang rating kasi nga magagaling yung mga consultant na inilagay niya diyan na experts sa personnel. Pero pag during actual implementation biglang pinalitan, no? At hindi nagpaalam at walang reason, justifiable reason bakit papalitan, bawal po yan. So that would be a ground for blacklisting kasi nga hindi po madidefeat po yung purpose ng pag-evaluate natin, and we relied, no, on the submitted names ng mga personnel, ng mga credentials nito, and then it turned out na hindi pala yun ang maibibigay sa project site or sa implementation, then pwede po yan maging ground for blacklisting. Okay? Of course, unless na may justifiable reason na namatay yung certain personnel, siyempre hindi na dapat kailangan palitan. Pero dapat acceptable, no, sa procuring entity yung ipapalit, no? Sama po yan sa terms of reference. Okay? Number 4, for the procurement of goods, unsatisfactory progress in the delivery of goods by the manufacturer, supplier, distributor arising from his fault or negligence and unsatisfactory or inferior quality of goods as may be provided in the contract, no? So very important 'yan, no? Kasi nga kaya nga tayo nag-outsource ng mga gamit na ito kasi nga hindi available sa atin at we expect, no, that they provide, no, the needed delivery, the goods in good condition, no, as specified in the bid docs. Kung hindi nila may negligence na nangyari, no? Say for example, ni-deliver nga yung particular goods pero nasira, no? No, say for example, naulanan or naapektuhan, no, based na baha, no, ganon. So hindi nasira, so hindi nila maayos na na-deliver, then that would correspond to and then hindi nila pinalitan yung kanilang deliver kasi hindi naman dapat natin tanggapin, no? Walang acceptance na ganon kasi nga sira bakit mo na i-accept yan? Maging liable pa tayo diyan. So that would be a ground for them to be blacklisted kung hindi nila papalitan yung kanilang dineliver na inferior quality, no, or nasira ng mga items dahil sa kanilang negligence. Okay? Meron naman usually ang mga insurance, so dapat covered yan ng insurance nila if ever, no, na due to fortuitous event, no, nangyari yan. Number 5, for the procurement of consulting services, poor performance by the consultant of his services arising from his fault or negligence, no? So yung mga consultant natin na na-hire, if ever na binigay naman natin ang mga counterparts na required sa atin, say for example an office or equipment or a vehicle, no, na required sa terms of reference, then hindi pa rin niya ginampanan yung kanyang expected na mga deliverables, then pwede po yang maging ground for blacklisting ng particular consulting services or consultant, no? Pero kung ang reason behind the poor performance ay dahil hindi tayo nag-provide ng mga counterparts natin as required under the terms of reference, then hindi po yan pwede maging valid ground, no? Kasi expected yan Say for example kasi walang opisina yung particular na consultant doon pero nakalagay sa reference, terms of reference na tayo ang magbibigay or magpo-provide, no? Based sa terms of reference tayo ang magpo-provide ng kanyang office space, ang kanyang mga equipment, no, para makapag-perform siya sa kanyang responsibilities, then dapat ibigay natin kasi kung hindi po yan valid ground for blacklisting kasi nga ang resulta niyan ay hindi talaga niya ma-deliver yung kanyang requirement kasi nga hindi tayo nagbigay ng counterpart. Okay, so number 6, for the procurement of infrastructure projects, poor performance by the contractor or unsatisfactory quality and or progress of the work arising from his fault or negligence as reflected in the constructor's performance evaluation system, rating sheet, or the CPES, no, or the existing performance monitoring system of the procuring entity. So yan po yung mga basis natin, no, pag-determine kung ano po considered poor performance, yung CPES or yung performance monitoring system natin sa procuring entity. So kung turn out na ganun talaga, masyado na mataas yung slippage, may negative slippage, at puro papalpak, no, or mga substandard ang ginamit ng mga materials, or mali-mali yung mga ginawa ng mga procedures as expected sa mga standards, then pwede po yan maging ground for blacklisting. Willful or deliberate abandonment, no, or non-performance of the project or contract by the contractor resulting to substantial breach, no, thereof without lawful and or just cause. So, yan po, dahil posible yan kasi nga yung mga ibang contractor kasi marami na masyadong contract na pinapasukan, no, at hindi po nag-falsify pa most likely ng document, no, tulad ng yung list of ongoing contract and contract awarded but not yet started, hindi po niya nilista lahat, no, to make it appear na kaya pa niya, malaki pa yung kanyang NFCC, no, pero totoo pala, marami na pala pa siyang maraming mga kontrata na nakuha pero hindi pa nasisimulan, so hindi na niya kaya, no, na ma-deliver yung kanyang responsibilities. Yan po ay magiging ground po yan, no, na minsan iniiwan na lang, no, iniiwan na lang ng contractor yung mga hindi pa tapos na mga projects dahil nga kulang-kulang na yung kanyang capital, wala na siyang equipment or manpower ba, no? So yan po yung mga resulta. So pwede po yan maging ground for blacklisting kung hindi justifiable, no, yung kanyang pag-iwan, no, ng ating mga project na nakatiwangwang. Okay? And then in case it is determined prima facie that the contractor has engaged before or during implementation of the contract in unlawful deeds and behavior relative to the contract acquisition implementation as enumerated in Section 3D of the Guidelines on Termination of Contract. So yun po yung mga termination of contract procedures. Kung nagawa na po yun at nakita po na meron talagang violation, then pwede po yan maging ground for blacklisting. Okay? So ano po yung sanction? Basically the same, no? Sanctions na nakalagay sa ating procurement stage ng blacklisting procedure. First, yung security, no? In this case, performance security ng tawag natin kasi nga nasa contract implementation stage na tayo. So yung performance security may forfeit, and then first offense, blacklisting for 1 year, second offense, blacklisting for 2 years. Wala po tayong bid securing performance securing declaration dito. Pero I understand meron siya kung sa emergency cases, no? Meron tayong tinatawag na performance securing declaration. But in this case, wala po siya. Performance security lang po yung regular forms of performance security ang allowed. And then without prejudice to the imposition of additional administrative sanctions as the internal rules of the agency may provide and or further criminal prosecution. So nakalagay po dyan kung meron, no? Kung meron po tayong kasi yung mga malalaking departments tulad ng DPWH, no, mga DNR, meron po sila mga constitute grounds for blacklisting as enumerated earlier. The implementing unit, I mean, shall within 7 calendar days after the lapse, no, project duration, cause an execution of a verified report and with all relevant evidence attached, no, that particular verified report subject to the following procedure. So yan po yung procedure natin. Unlike in the procurement stage, ang initiation po ay manggagaling po sa observer, sa bidder, at saka sa back. But this time, wala na pong back dito kasi implementation na ito, so hindi na po involved yung Bids and Awards Committee. But of course, the Bids and Awards Committee can always assist, no, sa paggawa ng verified report ng ating implementing unit, no, for this particular procedure. So, ito po yung procedure natin, notice of blacklisting, show cause, and then decision. So, himay-himay natin ito. So, the notice of blacklisting ay upon recommendation by the implementing unit, no, the hope shall initiate the blacklisting procedure by a written notice to the contractor with the following information. No? So, the statement of the acts that constitute the grounds or for blacklisting. So ano po yung particular act na nagiging ground for blacklisting. And then an instruction to the contractor to show cause as to why it should not be blacklisted. No? And special instructions of the procuring entity, if any, no, the notice of blacklisting shall be accompanied by a copy of the verified report. So yan po yung mga nakalagay sa written notice. No? So dapat naka-attach po yung verified report na ginawa ng ating implementing unit. So minsan dito po mali, no, yung ating hope, no, kasi nga dito naghahanap ng palusot yung mga iba blacklist na sana at pupunta sa korte dahil nga hindi tinupad yung procedure na ito, no. So pwede po maging gusot yan kung hindi po tayo sumunod sa procedure na ito. Show cause within a period of 7 calendar days from receipt of the notice of blacklisting, the contractor shall submit, no, to the hope a verified position paper stating why it should not be blacklisted. So may opportunity naman na sumagot, no, kaya nga nag-issue tayo ng notice para mabigyan siya ng opportunity within 7 calendar days from receipt of that particular notice. And if the contractor fails to show cause after the lapse of 7 calendar days, then either by inaction or by default, then the hope shall issue the blacklisting order na, no? Kasi wala naman siya natanggap, meaning hindi siya interesado, no, yung ating entity. And then ang decision within non-extendable period of 10 calendar days from receipt of the verified position paper, the hope shall decide whether or not to blacklist the contractor. It shall serve a written notice to the contractor of this decision which shall become final and executory after the lapse of 7 calendar days from receipt of the notice of decision. Okay? So yan po yung ating procedure ng ating blacklisting during sa ating contract implementation stage. So kailan ba magiging final and executory itong ating blacklisting order? No? So depende po yan, no? Meron po tayo mga tinitingnan na sitwasyon. So first, kung wala pong final na MR, no, or motion for reconsideration sa decision na ginawa ng ating hope, no, to suspend, then the decision become final and executory after the lapse of 7 calendar days counted from the receipt of the notice of decision. Pero kung meron namang final na MR pero walang appeal, no, so i-discuss muna o i-entertain muna yung MR, no. The decision become final executory after the lapse of 7 calendar days kung na-denied na yung motion for reconsideration, no. So counted from the receipt of the resolution on the motion for reconsideration. So depende po yan, ha. Yung una, wala pong MR, walang appeal. Yung pangalawa, meron pong MR, walang appeal. So magmamatter po yan kung kailan magiging final executory. So this time, tatapusin muna yung resolution ng MR and then doon bibilang ng 7 calendar days. And yung pangatlo, kung merong appeal, no, after na file yung MR, then the same was denied, then the decision become final executory upon receipt by the agency and or person or entity concerned of the decision on the protest or the appeal. Okay? So yan po yung sitwasyon na dapat nating tingnan kung kailan magiging final and executory, no? So ano po yung impact, no? Ano po yung consequence, I mean, no? So kung meron pa mga pending na mga procedures na dapat gampanan. So ito, before issuance of the blacklisting order, ano po ang consequence? No? Ano po yung mangyayari sa iring contractor? So kung wala pa pong nalabas na blacklisting order, ang impact po nito sa contractor ay pwede pa po siya mag-participate, no, sa procuring. Yung kung meron ng blacklisting order na na-issue pero wala pang NOA, no? So the blacklisted person entity shall not be qualified, no, for award, and the such project shall be awarded to another bidder pursuant to RNT 184 and its implementing rules and regulations. So meaning to say, kung nakapag-participate nga siya sa ibang entity pero biglang lumabas yung blacklisting order, hindi pa lumalabas yung award for that particular opportunity, then madi-disqualify na po siya na mabigyan ng award kahit siya po yung lowest calculated responsive bid o siya po yung highest rated responsive bid for that particular opportunity. And then the particular procuring entity would go through a process again, no? So doon sila sa second lowest or sa second lowest nga to evaluate kung qualified ba o hindi. So hindi po nila i-award yon, no, yung notice of award sa blacklisted entity, no, before the notice of award was issued. Okay? And then last, kung blacklisting order issued after, no, the NOA. Kung na-issue naman siya yung blacklisting order, meron ng award na nabigay, itutuloy lang ng particular bidder or contractor, yung na-award sa kanya na kontrata, i-implement na po niya, itutuloy lang kasi hindi po nahabol, no, hindi po nakaabot sa cut-off yung kanyang NOA, no, na-release na po ang award bago lumabas yung blacklisting order. So the awarded project or contract shall not be prejudiced by the said order, provided that said offenses are not connected with the awarded project or contract. So isa din yan sa titignan natin kung yung na-award ba na kontrata ay yung violation ba na blacklist siya, hindi po pareho sa kanyang na-commit, no, doon po sa isang kontrata na na-award sa kanya. Kung related po yan, then ma-forfeit po, marirevoke po yung award na nabigay sa kanya kung related, no, sa project or sa offense na nagawa niya yung awarded contract sa kanya. Pero kung hindi naman, so pwede po niyang ipatuloy yon o itutuloy yung implementation na yon. No, hindi po yan madadamay sa order na lumabas after the NOA. Okay? So effectivity period for the penalty shall be clearly specified, sabi natin kanina, in the blacklisting order and shall commence at the same date of its issuance. Take note, same date of its issuance, effective na itong blacklisting order. Kahit hindi pa ito na-upload sa ating online blacklisting portal. Kasi meron niyang gap, di ba? Meron niyang delay. Minsan, 3 days, no, na bago siya na-upload, na-issue na po siya 3 days ago. So effective yun immediately upon issuance, no, of the blacklisting order. Blacklisted na po siya. So doon po tayo magre-record, hindi po sa date of uploading sa blacklisting portal, no, yung ating order effectivity. So dapat very careful tayo yung mga nagpo-postqual to ensure na gawin natin yung postqual, hindi tayo magre-rely lang sa ating consolidated blacklisting report na nasa GPPB technical support JPPB website. Kung hindi, tayo dapat ay tumawag din, no? Mag-check sa mga previous contracts na award sa kanya o sa particular bidder na ito na pinopostqual natin to check kung wala ba siyang blacklisting order na nilabas, no? Kasi nga may delay yan, minsan may gap, no? To ensure that we are doing the due diligence required or expected of us. Okay? So ito po yung application of penalty, no? Sabi ko nga kanina, meron tayong 1 year first offense and 2 year second offense. And then for the kung more than 3 and more na ang kanyang offense, then masasakop na po yan sa baba. So kung hindi naman less than 3 pa yung kanyang offense, then masasubsume yan, no, ng kanyang remaining period of the previous blacklisting order. So 2 years yan po na blacklisting order kasi more than 1 na yan, more than 1 offense na yan, no? So 2 years yan. Pero masasubsume yung previous niya na blacklisting order. Magiging 2 years yan overall. Pero kung 3 and more na kanyang na offense na na-commit at na-issuean siya ng blacklisting order, so mag-multiply yan kung ilang offense yan na-commit niya sa kanyang period of blacklisting. So posible yan more than 2 years. Okay? So ito po yung sinasabi natin kanina na form, no? Blacklisting order form na standardized na po yan, prescribed po yan ng GPPB through its circular number 3, series of 2020. So madadownload po yan natin sa GPPB website, nandyan po yung link. And then nakalagay po dyan very clearly stated na should not be modified. No? Bawal po tayo mag-modify ng itong format na ito. Dapat consistent yung ilalabas nating blacklisting order form sa itong format na nakalagay. Ang gagawin lang natin is to supply, no, the needed information and to provide the necessary tick marks sa mga boxes na nandyan na applicable sa ating order and to supply the information required, no, and pipirmahan. And ito po yung i-upload natin sa online blacklisting portal. No? Standard po yan na form, hindi po pwedeng baguhin. Okay? So hindi po natin hihimayin yan, pero ito po yung expected, no, na nakalagay dyan sa ating blacklisting order form. No? The blacklisting order duly signed by the Hope or Appellate Authority shall contain the following: no? Department or office order or board resolution number of a particular case, and then complete registered business name, address, and PhilJEPS registration number of the blacklisted person or entity. Kasi nga matatanggal po yan, so, sa PhilJEPS yung kanyang certificate, yung eligibility niya, no, sa certificate na in-issue ng PhilJEPS. So hindi po siya eligible na makapasok pa ng kontrata o nabigyan ng opportunity during the period of blacklisting. License number, if applicable, authorized managing officer, name of project, contract, and location or amount, specific ground or offense na na-commit ng particular contractor, at yung sanctions, no, yung specific duration, dapat very clear yan. Start and end date. And then date of issuance of the order to blacklist. So any information dito na nagkamali kayo, sabi ko nga kanina, sa knowledge check natin, na pwede naman, no? Pwede naman yang baguhin, no, ng ating or blacklisting order entity, no? Na once na discover na may pagkakamali yung nalagay nila sa blacklisting order form na kanilang na-upload. Okay? So we are down to the knowledge check before we proceed to the open forum. Last na po ito. Mamunik?
Yes, Director Ricky, that's right po. No, we have reached our final knowledge check question for today's program. So for our final knowledge check question, the question is, when does blacklisting order become final and executory? Again, the question is, when does blacklisting order become final and executory? Letter A, if the bidder did not file an MR on the decision to suspend, said decision becomes final and executory after the lapse of 7 days counted from receipt of the notice of the decision. Letter B, if the bidder did not file a protest after his MR has been denied, the decision becomes final and executory after the lapse of 7 days counted from receipt of the resolution on the motion for consideration. Letter C, if a protest was filed and the same was denied, the decision becomes final and executory upon receipt by the agency and person or entity concerned of the decision on the protest. Or letter D, all of the above. Ayan. For our Facebook Live viewers, drop your answers through our comments section. And currently we have 45% who are answering our final knowledge check question. Sige, let's give few more minutes po for our participants to answer our poll. All right. Sige po, let us have the results, please. Ayan, Director Ricky, 72% po answered letter D, all of the above. 12% answered letter A. 12% answered letter B, nagtypo sila, and then 4% answered letter C.
Okay, so meron pa rin nalito, no? Pero I'm happy to note that karamihan naman ay
Yes, sir.
naintindihan yung ating pinagsasabi kanina. So na-emphasize po natin ito kanina, na-discuss po natin ito, no? Kasi nga in order to determine kung kailan final and executory, depende po yan, no? Kung merong MR, kung merong appeal, or kung merong appeal ang ginawa or sinubmit yung ating contractor, no? So kung magdidepende po yung determination ng final executory ng ating decision to blacklist. So dapat all of the above, kasi yung stated na choices, yung A to B, A to C, ay kasama po yan sa mga sitwasyon na discuss natin earlier. So the answer is all of the above. Okay?
Ayan. Thank you very much po, Director Ricky. And I think that actually ends our discussion proper. Again, thank you very much po, Director Vicky Sanchez. Now, to proceed with the course of our program, let us first watch again po a very short visual presentation, audiovisual presentation on government procurement before we actually jump right through our next and final open forum. So perhaps we'll see each other again after 5 minutes. Thank you all.
Have you ever wondered how sharing of issued blacklisting orders could be made easier for your agency? Well, with the Online Blacklisting Portal, or OBP, you are only one click away from posting and updating the status of your blacklisted entities and accessing information related to your agency's blacklisting history. Let me give you a quick walkthrough of the new OBP. To register, visit the link flashed on your screen. One registration per PE is allowed and only the official user can request for registration. After the successful registration, an alternate user can be added. Your registration will be validated upon receipt of the documents flashed on your screen. Within 3 days from the effectivity date of the BO, PEs should be able to post the BO by filling out the form in the OBP and uploading the copy of the approved BO. You can simply click on the Update Status tab from the Blacklisting Order Details screen. In case you need to change or update your account details, you may send a request to the email address flashed on your screen. For more details, you may visit the OBP homepage to access these files.
I hope everyone is back. Again, that was a short audiovisual presentation on government procurement and on GBPBTSO online training management system evaluation procedure. For more quick guide on government procurement and other related short videos and audiovisual presentation, you may visit our official website at www.gbpb.gov.ph. To proceed with our second and final open forum, once again, let us have Director Vicky Sanchez. Sir, I believe we have 4 questions po, sir, if I'm not mistaken, under blacklisting guidelines. So let us start with the first question, please. Ayan, medyo mahaba-haba ito, sir, for our first question. In case the respondent refuses to receive the show cause order, what will be our course of action? What will be our reckoning date for our succeeding legal action? Do you have standard formats of show cause order and decision? I believe we need to undergo training on this since dispensing quasi-judicial function is very technical.
Okay,
We have 3
so
questions, sir.
ba siya? Yung isa kasi nasagot na natin, no, yung meron pong standard form, yung ating sige, sabi natin. In case the respondent refuses to receive the show cause order, what will be our course of action? Yan muna. So basically, para to ensure na matanggap talaga, mini-mail po natin yan through official courier. No, hindi po natin pina-personal na pinapadala yan kasi nga to avoid this particular situation from happening na ayaw tanggapin, no, kung tayo ang magde-deliver. So it should be of course through the official courier kasi nga kahit sino naman tumatanggap naman yan, no? Hindi naman nila alam kung kanino galing yan. No? So tatanggapin talaga yan to avoid the situation. And then what will be our reckoning date of our succeeding legal action? So yun po, kung kailan po natanggap based on the courier, na once na napadala natin sa post office, yan na po yung date na re-recon dapat, no, yung ating number of days to show cause order and decision. And then yung statement niya kailangan niya mag-undergo training, so depende po yan, no, sa inyo. And then I believe there are available naman ng mga learning and development opportunities for this that you may tap, no, to help you further in doing this particular na mga responsibilities.
Ayan, thank you very much, sir. Moving forward to our next question. Is there a liability on the part of the PE if they did not impose blacklisting to an airing contractor?
Wala namang specific, no, or explicit na nakalagay kung merong liability yung procuring entity who was not able to impose the blacklisting order to a particular airing contractor kung dapat naman talaga mag-impose. Pero ang effect po kasi niyan sa government ay magiging marami po magiging victim, no, ng mga procuring entity kung hindi po tayo mag-impose ng blacklisting sa isang airing contractor. Kasi nga mabibigyan pa rin sila ng kontrata at patuloy pa rin yung procurement opportunity na papasok sa kanila. So responsibility natin yan as a procuring entity to religiously, no, comply, no, with this particular guidelines na i-blacklist dapat ang i-blacklist, no, karapat dapat ang i-blacklist as long as we follow the correct procedure. Kasi we will be in remiss kung hindi po tayo tumupad sa pag-conduct ng pag-issue ng mga blacklisting order. Yun po ang impact, no, magiging negative impact po yan sa ating kabuuan sa gobyerno kasi nga magpatuloy lang na makakatanggap ng kontrata ang mga airing contractor at hindi po sila mapaparusahan. No, pero to state it clearly, wala po talagang specific or explicit provision nakalagay kung ano po yung liability ng procuring entity. Okay?
Yes, thank you very much, Director Ricky. Moving forward to our third question. How can we assert if there is a connivance before or during the bidding process?
Yun nga, ito yung isa mahirap dyan. Kailangan talaga nyo mag-gather ng enough evidence, no, to be able to prosecute itong mga ganitong mga gawain. So it is very crucial on you. Meron kayong mga ways, no, mga internal rules siguro ninyo, ng procedures na pwede makapag detect ng itong mga ganitong mga connivance sa bidding process. Kasi nga even mga experts mahirap talaga to i-prove sa court, no, kung kulang ang ating ebidensya. So it's up for the procure entity to establish its own internal
such decision.
As to the permanent suspension, depende na po yan sa ating korte, no? Kasi wala po tayong way of permanently disqualifying or suspending a particular bidder from participating in the bidding process kasi nandyan po nakalagay yung first offense 1 year lang, second offense 2 years, and so on, no? So yung perpetual disqualification, ang korte na po ang mag-decide niya na mag-impose ng perpetual disqualification for violation of certain acts, lalong-lalo na yung sa RA 9184 na enumerated acts na ma-fall doon sa criminal liability, no? So pero in this case, ito ay 10% lang naman na liquidated damages na na-impose. Pwede pa, hindi po siya ground for perpetual disqualification, pero ground po siya sa poor performance, no? Doon po siya magpo-fall. So blacklisting order lang po ang ating may impose dito at 1 year or 2 years lang po, and then malilift na po yan. So yan po, and then of course yung ating documents to show yun po yung mga evidence natin sa mga tulad ng CPES, no, at saka yung ating internal monitoring performance monitoring system to provide the evidence na meron talagang poor performance at negative slippage na umabot na ng 10% liquidated damages itong ating contractor.
All right, thank you very much, Director Ricky. I believe that was our last question. Again, thank you very much, Director Ricky Sanchez, for answering all questions raised for both learning session 1 and 2. If you have any more questions, you may still ask them out by visiting slido.com. All you have to do is to just type in the event code #governmentprocurementph, to which the GPP-BTSO will answer through an assurance or through FAQs. You may also request for legal consultation on your specific concerns, no, of your respective municipalities from our office. All you have to do is to visit our official website at www.gppb.gov.ph to know more about the fuller details and process. So at this point, we would like to thank again our resource speaker, Director Ricky Sanchez, for all the time accepting our invitation and for providing us a very profound lecture discussion. Now, before we proceed to the final reminders, allow me to provide a recap of our today's learning session. For today, we had an entire session on protest mechanisms and remedies, where we had a comprehensive discussion on the penal, civil, and administrative provisions, as well as an in-depth discourse on the liabilities under Republic Act 3019. We also had a profound discussion on the requisites for filing a request or motion for reconsideration and valid protest. Towards the end of our learning session, we likewise discussed the procedure to resolve a protest. We also had a fruitful discourse on the blacklisting guidelines, where we highlighted its uniform guidelines issued by the GPP-BTSO. We also discussed and identified the grounds and sanctions for blacklisting during procurement stage. Finally, we also had a meaty discussion on the blacklisting procedure during the stage of contract implementation. Both Elian Jr. of the Department of Budget and Management, Region 11, and Regional Director Ricky Sanchez of the Department of Budget and Management, Regional Office 7. We are very much honored and grateful for all the time accepting our invitation po, and for selflessly sharing your knowledge and expertise to our participants. And of course, we would like to similarly and equally thank all of our participants and to our Facebook Live viewers po, for your consistent high spirits during our week-long virtual event. We do hope that you were all able to really have a deep dive on all of our learning sessions, and that you were able to equally enjoy our learning spree. We are in great hope po talaga na lahat ng mga baon-baon po nating mga questions, ano mga tanong po on specific concerns po of your respective municipalities were answered, and that our event were able to provide enlightenment. Rest assured that all of the information gathered for this online training shall be treated with utmost confidentiality, consistent, of course, with the provisions of the Data Privacy Act. Also, for our early bird winners and knowledge check winners, again, congratulations po, and then kindly check your respective emails or chat box and kindly respond po with the details needed for the shipment of your special tokens. Also, very important din po, no, please do not forget to evaluate our resource speakers and of course our entire virtual training through the GPPBTSO online training management system using the control number emailed to you by our event secretariat. All you have to do po, no, sige po, I'll just quickly have a mini tutorial po on how you can evaluate our entire training and of course our resource speaker. All you have to do po, no, kapag nag-login na po tayo sa atin pong GPPBTSO OTMS, we will be arriving to this dashboard, and then all we have to do is to click evaluate po. Yan po yung nakikita po nating red box po sa atin pong lower left side of our Zoom screens. All you have to do is to click that, and then next slide please. Ayan po, when you click that, maglaland po tayo sa page na yan where we will see ito pong first red box. Hold on. All you have to do is to click po yung atin pong first red box na general evaluation po. And then after that, you have to accomplish or answer all the required sections po and then click submit. Then after clicking submit, you will have to return on this page. And then after a while, makikita nyo po yung list of all of our resource speakers from day 1 until day 5. And all you have to do is to just click the eye icon under the evaluate column and just please do the same. Ayan po, and then click submit for all po, ano, for all of our resource speakers from day 1 to day 5. Ganun lang po kadali. All right, so if you have any more questions or you need assistance, just feel free to ask or coordinate with Ms. Jocelyn Bislig or Mr. Marky Duetes or any of our GPPBTSO event secretariat. Ayan, so finally, to commemorate po this learning session with Director Ricky, may we request everyone to please switch on their cameras. Again po, we shall be having 3 shots po, no, in my count. Last grouping na po natin ito, so hopefully everyone will grant us, no, na i-open po ang kanila pong cameras. Ayan, napakaganda pong tingnan na tayo po ay nagkikitaan even virtually po, no. Ayan, so for our first shot, sige, browse through ko po muna. Meron pa rin pong mga ilan-ilan, probably, no, dahil po sa internet connection, but ayan, marami na po tayo. So for our first shot, ready, 1, 2, and 3. Yeah, for our second shot, ayan, may humabol po. Thank you very much, ma'am. For our second shot, ready, 1, 2, and 3. And then for our final shot, ready, 1, 2, and 3. That's it. I think that's it. That concludes the online training for the Municipal Local Government Units and Government Procurement Reform Act, or the Republic Act number 9184 and its 2016 revised implementing rules and regulations, batch 9. On behalf of the Government Procurement Policy Board Technical Support Office, this has been your facilitator, Monica Marie Sadia. Maraming salamat po at mabuhay tayong lahat. Thank you.